Introduction 1175, sponsored by Councilmember Menon, would establish a program to provide domestic violence survivors with legal representation throughout a divorce proceeding. The Office of Civil Justice, OCJ, would be required to submit an annual report on the program to the Mayor and the Speaker of the Council. Delivering services to survivors of domestic violence is incredibly important. Our city's network of family justice centers, domestic violence shelters, and non-residential community services are critical components in providing life-saving support. If anyone listening needs help, they can contact 311 or New York City's Domestic Violence and Sexual Assault Hotline at 1-800-621-4673, HOPE. As required by Local Law 5 of 2022, HRA convened a work group with the Mayor's Office to End Domestic and Gender-Based Violence, NGBV, and the Administration for Children's Services, ACS, consulting with stakeholders, including legal service providers and domestic violence survivors. The work group provided important analytic routing as the city began to think through the challenges posed by establishing a program to provide these legal services within the context of a 24-month pilot proposed in Local Law 5. There are significant challenges in determining the scope of service provision required in this area. Readily available data along a number of dimensions important to provision of this kind of legal assistance is limited, including data on the number of contested matrimonial cases in New York City Supreme Court where one or neither party is represented by counsel, or the number of cases related to domestic violence. That kind of data is important because it would inform contract design, crafting the appropriate contours of the contracts for legal service delivery such that city dollars would be focused on the individuals and types of cases that are most underserved. Program design would also be informed by understanding, given a limited budget, whether it would be more important to focus on brief legal assistance or full representation, and if both, in what proportion for each. An additional challenge the workgroup highlighted is the timeline of divorce proceedings. The most contentious divorce proceedings can take more than 2 years, impacted by factors like child custody, the complexity of property disputes, and the court's workload. Where providing full representation in the pilot, the city would have to craft a program sensitive to the fact that it is irresponsible for a provider to drop a client in the middle of a contested divorce. Conversations with OMB are ongoing with regard to funding Local Law 5 of 2022. Local Law 5 serves as an important bridge to a potential broader legal services program for domestic violence survivors. While conscious of the boundaries of our capability to establish such a program in short order, the data limitations to program design, and the fiscal implications of such a program, DSS remains aware of the impact a matrimonial legal services program could make in the lives of survivors of domestic violence. Alongside our NGBV and ACS partners, DSS stands ready to continue the conversation with the Council. Introduction 791, sponsored by Councilmember Ressler, would require DSS to post on its website each month data concerning vacant supportive housing units, including the total number and percentage of all supportive housing units in the city that are vacant, as well as the number of vacant units at different stages in the placement process. DSS would also be required to provide data beginning 12 months prior to the enactment of the law. Transparency is an important goal, and we are open to partnering with the sponsor and the Council to deliver timely, accurate data on vacant supportive housing units. There are significant aspects of the legislation we would want to discuss in further detail to achieve that goal. For instance, harmonizing this proposed report with existing reporting and methodologies for reporting on supportive housing vacancies would mean DSS would be able to deliver this report in a cost-effective manner. Aligning definitions across reporting already in place would allow for creation of a proposed report without having to fundamentally restructure logics, programming, and databases used to produce a report. Note that misalignment would result in a report that is onerous to produce, costly, and undeliverable in a timely fashion. Furthermore, looking at vacancy data in 2 different reports with different approaches could lead to confusion. In this area, HRA would want to leverage the ongoing work of HRA's Office of Supportive and Affordable Housing and Services, OSAS. The OSAS team is committed to ensuring that supportive housing vacancies are monitored and filled quickly. OSAS has developed sophisticated reports to review all vacancies in CAPS monthly. The occupancy rate for the OSAS referred units is 96.4%, and we feel these tools have been instrumental in the increase in occupancy rate. The reports OSAS creates are used to constantly monitor the system, identify issues, and implement interventions where needed. Introduction 1208, sponsored by Councilmember Gutierrez, would require the Department of Homeless Services, DHS, in coordination with DSS, the Department of Housing Preservation and Development, HPD, and the Department of Youth and Community Development, DYCD, to issue a one-time report to the Mayor and the Speaker of the Council on the availability of air conditioning in homeless shelters. The report would detail which shelters have air conditioning, identify shelters with air conditioning only in some areas versus the whole facility, specify the types of air conditioning systems used, highlight shelters that need air conditioning repair, and provide information on shelters that have installed air conditioning in the past 12 months or plan to do so within the next 12 months. DHS recognizes the critical role that high-quality shelter facilities play in meeting client needs. DHS has expressed its commitment to phasing out operations in sites that no longer meet agency standards and transitioning to sites that better accommodate clients, continuously seeking to raise the bar in shelter quality and client care. As part of this ongoing commitment, DHS has issued an addendum to the current nonprofit social service provider open RFP that all new shelter sites include air conditioning. Currently, the majority of DHS sites have site-wide air conditioning or a cooling room, and this RFP addendum continues to build on our long-standing focus on enhancing shelter quality. DHS recognizes the importance of transparency in this area and welcomes further dialogue with the sponsor and council regarding Introduction 1208, specifically the granular level of detail required by the report and privacy challenges associated with the report. Introduction 1208 calls for the production of data on air conditioning at sites at a level of granularity that would pose serious challenges for DHS to produce. Given the size of the system and the diversity of air conditioning setups, DHS does not maintain a centralized tracking system of air conditioning repairs, as such maintenance is managed directly by individual shelter providers. However, DHS is kept informed of any major air conditioning or heating issues that impact shelter operations and clients. Additionally, DHS has concerns regarding client privacy, confidentiality, and security related to the reporting requirements on Intro 1208. Two key factors underlying DSS's focus on privacy in direct or indirect shelter address disclosure. First, clients deserve to retain dignity during the time they are in shelter. Second, there are serious security considerations DSS must take into consideration on an ongoing basis with respect to shelters serving survivors of domestic violence and the potential for disclosure of their addresses. Introduction 1232, sponsored by Councilmember Banks, would require HRA to provide an automated text message or email notification upon the approval of an application for the Emergency Assistance Grant Program pertaining to rental assistance. Such approval notification would be delivered to the tenant applying for assistance and the building owner or managing agent designated by the building owner to collect rental payments from the applicant, to the extent that such information is provided in the application. Notifications would include information on the monetary amount of the award via the emergency assistance grant, an estimated issuance dates for the assistance, and the mode of delivery for the corresponding check. Access HRA is a critical tool in informing clients about the status of their case. Clients may opt to go paperless and receive notification via Access HRA. Otherwise, they will receive mail or mail and Access HRA notification updates as to the status of their case. We have various concerns with Introduction 1232, including privacy, the use of text message and email, and notice requirements. Given the outstanding privacy concerns, HRA does not support the Council moving forward with Introduction 1232 as drafted, but would like to continue conversations with the sponsor. Thank you to the sponsors and Committee on General Welfare for considering these introductions. HRA, DSS, and DHS remain ready to continue even more detailed discussions on the concerns and considerations I have outlined here today. I welcome your questions.
Thank you. I'm going to do something a little bit out of the ordinary. I'm going to allow members who have submitted bills to be heard today, an opportunity to ask questions first, and I'm going to start with Councilmember Ressler.
Thank you so much, Chair Ayala. It's my wife's birthday, and she will appreciate it. Thank you for your testimony, Administrator French, and I totally appreciate your suggestion to think about if there are ways to align other reporting requirements, and would welcome that conversation. We were, I don't use this word lightly, but disturbed by the data that Legal Services of New York foiled for late last year around supportive housing vacancies. And just want to try to, the data that you've referred to in your testimony is quite radically different. So I just want to see if we can get to some common understanding of where things are today. How many vacant supportive housing units are there in New York City as of today?
As of June 3rd, 2025, there are 5,092 vacant supportive housing units. Wow. Of that, just the vacant units consist of 56% of those units are state contracted units through the Office of Mental Health, 41% are city units, and 3% are federal units.
Did you say 67 and 41 or 57? 57?
I said 56 and 41.
56.
Mm-hmm. Of the 5,092 units, 44% or 2,226 have been put offline by the supportive housing providers and are not available for referral for a variety of reasons, much of it connected to unit needing significant repairs. Of that, 1,200 of these offline units are under contract by the state. 34% of the units, or 1,729, are actively in the referral process. 438 of those are re-rental units currently linked to an individual, so they would be shown as vacant because someone does not occupy them. But
tell me that number again. It's linked to an individual.
438 re-rentals are linked, okay. And then an additional 518 rent-ups, which would be new facilities, are also linked to units.
Okay, so you're saying that 950 are linked to people out of the 5,092.
Yes. I would say yes. I was saying that out of the 1,729 that are available for referral at the moment,
right.
And in the process, and then 22% are online, and the housing provider has not yet requested a referral. And of these, 64% are state contracted units. And I can say that for units that have not received a referral, OSAS tracks that monthly and then will provide that list of sites, facilities, and units that have not received a referral to the specific referral and contracting entities for those to have them follow up with those providers to understand what's going on.
I know this is not your job today, but you're a smart guy who's been doing this work for a while. Could you just give me your ballpark best estimate on the number of chronically street homeless New Yorkers?
I'm going to have to get back to you on that because I don't want to guess, and I know there is a number that DHS
usually
has.
It's talked about in the 6,000-ish range, 5 to 6,000 range. Those are ballparks that are often discussed. Is that fair? You're not going to comment.
I'm not going to comment.
I just mean to say that we have 5,000 vacant supportive housing units today, 900 of which are linked up to individuals, but well over 4,000 vacant supportive housing units today that could, with a housing first approach, potentially house the healthy majority of street homeless New Yorkers that are living on our subways and our streets today if we did the work to fix up those units.
Street homeless individuals is not the only individuals who need and can utilize supportive housing. So Understood. I would say the universe of individuals, who can benefit from supportive housing is broader than that. I would also say that the number of vacant units is not static in regards to what comprises that number is different over time, right? We do focus on units we have seen being vacant for extended periods of time by bringing those trends to the referral entities or the contracting agencies to have them follow up to understand what specifically is going on. I think also within a system like this, there is always going to be some type of, vacancy rate at any point in time. That's how a system works and moves and allows people to move in and move out. But I will say, from a tracking of the data, right, I think the city has made incredible strides over the last several years through the CAP system and the ways in which we have been able to utilize that system to run reports, which we would very much like to sit down and show you a little bit more in depth so you can see what is the information we have to align on the report that also meets what you are looking for in regards to transparency.
And just for my edification, the total supportive housing universe, it's 40-odd thousand?
In CAPS, it is 38,329. There are some supportive housing units not within, the CAP system.
So I would certainly agree with you. There's some vacancy rate that's healthy in a system. We're talking about a 13.39% vacancy rate, roughly. So that is not a healthy vacancy rate in a world where chronic homelessness is the top priority, I think, of many policymakers around the city. We know that the solution to homelessness is housing, and to have 5,000 empty units sitting there is, I think, embarrassing. And I think we have an opportunity. I mean, we have the same problems in NYCHA as the council members at this table know very well, Chair Banks and former Chair Aviles, and Chair Ayala, who has more NYCHA units in her district than just about any other in the city. We have the same problem at NYCHA where we've seen the number of vacant units explode tenfold since Eric Adams came into office, and we have a situation with 5,000 vacant supportive housing units. If we just did the work to actually put the resources in to fix up those units, we could make a tremendous difference in driving down our shelter population and our street homeless populations. I recognize those are not the only people who benefit from supportive housing, but it is one of the number one issues that every mayoral candidate talks about, that the mayor himself talks about, that we all hear from our constituents, is concerns about chronic street homelessness, people living in the subways, people who desperately need help, who we want to identify compassionate, effective solutions. This is the solution, and yet we have 5,000 vacant units of housing. So
Every vacant unit is not equal, and I think it's important that we understand that and understand within the system, but also within the units, right? Because there's also individual choice, right? We don't place someone in a unit. They get to decide that they want to live somewhere based upon the location of the building, how it's connected into their life, but also the unit itself. So there are some challenges in older units, right? Specifically, SRO units can be very challenging, where there's either shared bathrooms, shared bedrooms, shared kitchens, that individuals might want to wait for some of the newer units that come on.
I don't mean
There's
to be
also
flippant
a
or
level two. I just want to finish, please. There are units that are state funded that are level 2 clinical care units that provide a higher level of care, but also require a much larger share of an individual's income, where they also don't receive the same tenant protections as they do in supportive housing. So within the 5,000, I think there are some subset of those that are very challenging to fill. I don't disagree with you that at every point we should be looking to see how we can improve to fill vacancies, and that's what we do, but I just also don't think every unit in the 5,000 is equal.
I totally hear you. You are absolutely right. You laid out clearly also the different buckets that break down the 5,000 as well, and you just well articulated some of the barriers that we face in filling those units. But I would love to see prioritization from City Hall to actually activate and fill every one of those units, to get the resources in to make the necessary repairs. If there's a need for additional subsidies for it to actually work for the tenants and for the operators, let's make that happen. All of that is cheaper than paying for shelter. All of that is better for our community than people living on the streets, and for them, people themselves most of all. Like, none of it is acceptable. Like, while everything you said made sense, those are totally bureaucratic answers when people just want to see real solutions to these problems. And I get that, you know, we all live in the real world of having to navigate bureaucracy to solve problems. I wish that folks on the other side of this building invested the time, energy, and resources to actually solve problems through our bureaucracy and make things better. My last question, if I may, what is the process for dealing with cherry picking by providers or discrimination by providers that may violate applicable laws? Have you seen any trends in this area? How many times have DSS staff had to intervene in rejections by providers for applicants to supportive housing because the city was concerned the provider was creaming or violating applicable laws? Or is this not a concern that you're focused on?
I mean, we always track, right, referrals and try to identify, if, it seems as if providers are not accepting clients, right? The referral process, when the individual requests a referral, right, we refer 3 individuals to that unit that meet the appropriate eligibility requirements for that, right? And the provider is expected to choose one of those 3. I can't speak specifically to some of the things you're talking about, but we definitely track it. And if we
Follow up on those items?
yeah, if we see trends in that way, we'll follow up specifically with the provider and whoever the contract oversight agency
I appreciate
is.
that. We will send a follow-up email.
Okay.
Thank you, Chair.
Councilmember Banks?
Thank you. And thank you for the opening statement, Deputy Commissioner. When it comes to Intro 1232, and I know there's been concerns around the state law and PPI, I understand that there have been concerns that was raised by a staff member at DSS about the possible violation of state law related to handling of the PPI in my particular bill. I wanted to know, are there any, is there a specific law that is cited? And can you clarify which state law or regulation the agency believes may be implicated by this bill?
Sure. Thank you, Council Member. So Social Services Law 136 is the primary state law that governs individuals on public benefits, privacy and confidentiality of their private information. So that is the primary concern that we have.
Okay.
Happy to also have set up a meeting with the lawyers on my side as well who know more about it to talk a little bit more in detail, but that's the primary concern around protection and sharing of information
And that's on your end, sharing that information to a landlord.
Yes.
Information that is knowledgeable already by the landlord. When we're talking about address or the name of the tenant, I mean, I doubt you're just writing checks to the wind, but you are making a check out or to a particular individual or entity.
Yes, if someone's on subsidy, absolutely. If they're not receiving a subsidy and have applied for a one-shot deal, the landlord wouldn't have that. We can speak to landlords about a specific subsidy they're receiving, right? They might have questions to us about a check maybe that they didn't receive or that type of case. In that instance, we can speak with guardrails.
Well, this is a situation where
to the landlord around the subsidy they receive, not in particular about the individual connected to the subsidy.
But keep things in context. This is about transmitting payment to a particular entity or a landlord for arrears, right?
In regards to this bill, yes,
correct.
But the relationship, the landlord or the property manager would be a third party in this relationship. So the relationship is really between the agency and the individual requesting and applying for the benefit. So the communication is directly with them around what they've provided and then what our determination would be based on.
Are you aware, what are the documents needed to apply for a one-shot deal?
I can get back to you with the details, but it would be we would need
a lease?
A determination of
Would a lease be a document
a
that would be
statement
required?
of arrears, along with some other information. An individual would need to do an interview.
Would a lease be a document that would be required to present? To show that there's some type of contract or agreement between the two?
Yes, we would need some proof that the person is responsible for the rent of that particular.
And on that lease, it would list the landlord's information and the tenant's information as well?
Correct.
Okay. For the record, when it comes to landlord access to PII, regarding the issue of PII, what specific types of personal information does the agency believe would be at risk if a landlord were to receive status updates for one-shot deal applications or similar services? And given that the landlords already possess this information, such as tenant social security numbers, full name, other identifiers, what additional risk does the agency foresee?
One of the key components of the social services law and the confidentiality is actually the person being in receipt of public benefits and identified as someone as such. And that's the sort of overarching protection that social services law provides to individuals. So
But relegated to the identifiers that I mentioned: Social Security number, full name, the address. What would put that tenant at risk?
well, first, the methods
The
of
landlord is already privy to that
the
information.
methods, part of the information and concerns with that are the methods of communication over text message and email, which are not end-to-end encrypted. So there is concern in regards
Those are
to
transmission.
the transmission methods for those two things is a concern in regards to being able to ensure it's encrypted and protected and safe and doesn't inadvertently get.
Okay, when it comes down to like current payment delivery methods, what methods does HRA currently use to transmit payments for programs like one-shot deals? And are those payments sent via regular mail, electronically, or through other methods?
They are sent through mail. Primarily, it would be the overwhelming amount. There are some electronic payments. We can get back to you on the
For the record,
distribution.
HRA still sends checks by mail when it comes to arrears, or in this particular situation, an arrears to
Yes.
pay. Okay. When it comes to the information processing procedures, just circling back to the concerns around PII, what is the current process for collecting and processing information related to HRA services? And specifically, one-shot deals, how does the HRA verify and match the correct apartment, tenant, landlord to each application?
That information is provided by the applicant when they apply to us, such as through a lease. We would use that to verify, right, that there's a legal contract between the individual and the landlord.
What's the nature of the relationship with HRA and the landlord?
In a one-shot deal application,
Correct.
there would not be a direct relationship between us because the
Would the
arrears
lease,
are being provided to the individual. The payment would then be sent to the landlord, but the application and the determination is based upon the actual individual applicant.
But there is communications made
We will
to
send
the-
the payment. Yes, we send the landlords will receive payment, and it will indicate what the payment is for. But it is in most cases contingent on the applicant to inform their landlord when they have gotten a determination on the one shot. That one case you mentioned is concerning, so I'm going to ask my folks to also get information
that's
on
the
that,
reason
just because
why
I
we
would
drafted
like
this
to
bill. Right.
just know a little bit more what happened there, because that isn't
Okay,
how
well,
it
for the
should-
record, how are landlords currently notified, if at all, when payments are issued? And what information is provided to them?
So a landlord for a one-shot would receive notification through the mail with the checks indicating this is, the arrears payment for the particular individual that they have. There are limited situations where a landlord might receive more real-time information. In particular, I'm thinking of if in eviction case in housing court, where an individual has a legal representative, whether it's through right to counsel or someone they've retained, and the landlord has a representative. And so in the conversations between lawyers around settlement and coming to conclusion of it, the landlord's representatives might get have more up-to-date information because it's part of a proceeding and something the judge has sort of ordered to explore.
Hey, are checks being issued without clear confirmation that they are reaching the appropriate recipient? What's the check to make sure that the check reaches the landlord? And in a timely fashion that doesn't perpetuate the possibility of the tenant being homeless?
So as that relates to it, we do rely on the applicant and the lease to provide the correct mailing address for that. We will track things through returned mail that we get. We also, though, really are asking the applicants to ensure that they follow up with their landlord once we've informed them the award was granted, to let them know and confirm that they also received the checks.
Okay, and the differences in processing, like when it comes to like the RAD pack versus standard NYCHA, is there any difference in how one-shot deal applications or related services are processed for tenants in RAD pack developments compared to those in traditional NYCHA managed properties? And if so, can you explain how the processes are different?
So there should
They're the same.
be no difference between how they are being assessed.
Yeah, I just want to highlight the fact that the reason why this bill came about is because, and I'll just repeat portions of my earlier statement, we had a tenant who was basically evicted from her apartment. And during the intervention of my office, when we had reached out to HRA, they kept saying that it was approved or it was in process. It was being processed. And during that 3.5 week period, while she was actually sleeping on a friend's couch and moving around, the check somehow, some way made it to the management company in 3.5 weeks, and her being homeless. And the management company called and said, okay, we're going to open the doors back. We got the check. She can go back into the apartment. That was traumatizing for that particular tenant. And I don't believe that someone's housing should be in jeopardy because HRA decides to send a check through the mail, and or even just the lack of notification, especially to the landlord. Because had the landlord knew that the check was on the way, outside of just hearing it from the tenant, possibly that could have averted her being homeless and traumatizing her. And just highlighting the fact that this is, in this particular situation, this is a NYCHA development, and just showing again how the aggressive tactics used against tenants that are not done in traditional NYCHA. So I look forward to having continued dialogue. I'm hoping you'll come around to supporting this bill, and we can finally close this gap which continues to put trauma on tenants. Thank you. Thank you, Madam Chair.
Thank you. Administrator French, I want to just piggyback off of some of the questions that Councilmember Banks just asked. So do you know how many New Yorkers a month apply for one-shot deals for rental arrears?
Yes, it's approximately 19,000 a month.
19,000. Do you know how many of those are denied due to, I don't know, I'll give you one of the ones that I hear the most, missing documents?
I do not have the denial rates broken down by denial reason. We can look at that and get back to you on that.
Do you have the percentage of the denial rates?
Yes, so I just want to make sure I'm on the right place here. So the average approval rate for non-recurring applications is approximately 28%. And that can be due to a variety of different reasons as it relates to one-shot deals. There are state requirements as well, in particular around a future ability to pay the rent that has to be taken into account when determining if we would be approving a one-shot deal, but that is the average.
Okay, do you look into the data I'm trying to decipher here if the ESS, the HRAs more specifically, is looking into why the approval rate is at 28%, right? And if we're disaggregating data by, people failing to submit documents, right, which I hear regularly, then why, is that happening? Is it on our end? Is it on the applicant's end? Right. Because I've had, when you have a few people, saying, well, I had a difficult time, right, we expect that things are going to happen. A fax didn't get through, a letter didn't get in, but the majority of the cases that come before us are of individuals that have continuously say that they have submitted every document 2, 3 times, 4 times, and that they are repeatedly made to either resubmit or denied. And so that's troublesome because we should be tracking that and figuring out where the disconnect is to make sure that this process is a little bit more seamless. Because I agree with Councilmember Banks. This is a very stressful process for individuals that are facing eviction. And, you know, the more work that we can do to streamline the process and make it easier, I think would be beneficial for all of us.
I agree, and I think some of what's in Councilmember Caban's bill will also help, I think, address some of the potential miscommunication or misunderstandings, right, that may occur, and hopefully catch things a little bit earlier in the system. But we always are looking at ways in which we can improve it and figure out where things are on our side. What can we do to help change that?
Okay. I think I had a couple of others on this one. Do you know what percentage of cases, what the percentages of cases where a landlord did not receive a check or have any, or that led to an eviction?
I do not have that information.
I can't read my own handwriting, sorry. Okay, OMB provided a cost estimate of $64,000 in annual OTPS to operate and maintain the notification system required for this bill, as well as a one-time OTPS cost of $305,000 to develop the system. DSS already does similar work that is required by the bill, such as text messages, notifications that HRA sends for benefits such as Medicaid and fair fares. Can you provide a more detailed breakdown of what the cost estimated is for?
We would have to follow up with you on that, but there would definitely have to be system issues and changes, because the way in which we do communicate through text message and like email at this moment are very basic messages, such as like for Access HRA, like we all would sort of get the standard, like you have a new message or a new document has been posted to your Access HRA account, please log in to check it. Notifying individuals about a one-shot deal also has requirements at the state level through the Office of Temporary and Disability Assistance of what is sort of the level of information that must be provided within a notification of a application for public benefits. So there would definitely be additional system issues that would need to happen to be able to communicate in that fashion.
Okay. Additionally, DSS has capital funding budgeted for Access HRA and other HRA benefit assistance systems. Would the existing budget capital funds fulfill the cost needed to implement the requirement of this bill?
I will have to get back to you on that. I think
Did we submit these questions to you, Administrator?
I didn't get that detailed of a question. I have not seen, but I can't speak if the teams got it. They may, and I just might not have that in front of me. Apologies.
Okay. Just checking. All right. I'm going to move into intro 0791 in relation to requiring the Department of Social Services to post on its website data concerning vacant supportive housing units. I know Councilmember Bressler asked a bunch of questions. I just wanted to follow up on a few. Do you know how long on average units sit vacant?
That number can sort of be a variety of time based on many factors, but what I can say is, let me just I can talk about median times for individuals to get into units, but I would say vacant units, right, it really is on a spectrum. Most of them are not vacant for more, on the shorter end of like 0 to 6 months. And that could be due to, issues around turnover that's needed in regards to maybe there's minor repairs that need to happen. And then we do need to go through the referral process. And then depending on the units, the lease-up process might have additional requirements that are additional steps, similar to like if a unit has LIHTC funding, as part of the lease-up process, there's a special LIHTC packet that needs to be prepared, that needs to be reviewed and approved not by both the provider, but also by the third-party LIHTC representative.
Repairs?
No, for lease-up and moving in.
For
so
lease-up,
there are different aspects that may, require a unit to be vacant for a little bit longer, but it's actually linked. So that's similar to the 900 or so units I mentioned to Councilmember Ressler of like, they're listed as vacant because someone's not actively living there, but they're actually not available because they are linked to an individual and it's going through the lease-up process.
What percentage of those are because they need repairs?
I would have to get back to you in regards to that. I don't think our system has that sort of granularity, just because we are not we don't oversee the contracts for all of these units. So we'll have them listed as offline. We'll track it from a time point of view, and then we'll be able to provide that information in
Who
detail.
funds the repairs?
The repairs would have to be addressed through whatever agency holds the actual service contracts for the unit. So HRA holds contracts for a small number of primarily SROs, as well as like our HASA units. But DOHMH holds the majority of sort of like city units through 1515. And then the State Office of Mental Health is responsible for their units in regards to that contracting. And so providers would, if they need additional new needs to support repairs that aren't covered within, say, their existing contract, they would have to go to those particular oversights to request those funds.
Okay. Have you heard that the delays in repairs are due to funding issues?
I have not heard that, no.
Okay. Can you tell us how many of the vacant units are SROs?
Sure. So of the vacant units, 12% or 611 are SROs.
Okay. And do you know how many vacant units are in congregate settings versus scatter site?
I do not have the breakdown of congregate for scatter site. My apologies. We will get back to you with that.
Okay. How many move-outs of supportive housing are there on a monthly basis, and can you disaggregate by population type?
Sure. From June 1st, 2024 to June 1st, 2025, there were 3,325 verified move-outs from supportive housing, averaging approximately 277 per month. There are 9 different categories, so I could read them here, or we can just provide it to you after the hearing.
There are 9 different categories?
There's 9 different categories of
Okay.
supportive
Go
housing.
ahead, spill it.
Okay. Ishai is on average, is 4% of monthly move-outs. The general population is 8%. HASA single adults is 1%. HUD COC service funded is 2%. New York 1 and 2 are 17% of the monthly move-outs. New York 3 is 22%. New York NYC 1515 is 8%, and then SMI singles is 38%.
Okay, appreciate that.
And then there's other category, which is 0.
If you, yeah. Can you tell us what the average amount of time between the approval and the unit, for the approval for the unit and the move-in? And I know that you mentioned that before, but I didn't catch.
Sure. So the average. Let me just make sure I've got it here. So, median days. So, for an individual, the median days from their application to determination date of eligibility is 1 day. Their median days from determination date to referral date is 63. And then the median days from determination date to move-in is 139 for specific individuals. For most of the units that are vacant, we see that those are vacant. A majority of them are vacant from 0 to 6 months, though there are some that are 6 months to 12 months and some longer than 12 months. And obviously, the longer they're vacant, the more we focus on them with the contracting agency and the referral agency.
Okay. All right, I'm gonna move on to intro 1175 in relation to civil legal services for domestic violence survivors and divorce proceedings. In 2022, the New York City Council enacted LL5 of 2022, requiring a 2-year pilot project that would provide legal representation to domestic violence survivors undergoing divorce proceedings. What is the status of the pilot, and what is the anticipated cost of this pilot program?
Certainly. So at the time of the work group, the estimated cost for the pilot was $24 million over 2 years. That was done in 2022, 2023, so the estimate would need to be assessed again. Over the years at this point, the funds have not been able to be allocated for that pilot. We are in active conversations with OMB at this point about identifying funds to be able to move forward with the pilot, but due to a variety of different fiscal issues over the last several years, that funding was not able to be secured for this specific pilot.
So the administration didn't prioritize these dollars, even though this is a local law?
We looked at the local law. The local law was subject to appropriation, and based upon priorities, they were not able to be appropriated, but I can say we are in active conversations about it. So it is something we are still looking at and, hoping that we can do moving forward. So it has not been, put to the side. It's just, given the variety of different factors, it hasn't been funded yet.
I mean, it's disappointing to hear that, services as important as these, right, that serve such a delicate population are not a priority in the administration's, budget cycles. And so I'm really disappointed in that, because I remember sitting in on the first meetings when we were hearing this bill, and I'm on my way out. So we started talking about this bill maybe, 6 months into my term into the council, so maybe 7 years now. And we still haven't seen the pilot. Is there any assurance from the administration that it's going to be funded this year?
We are in active conversations with OMB to see if this can be funded, but those conversations are ongoing at this moment.
When would you know?
I'm sorry?
When would you know for sure?
I will get back to you, Ray, on a timeline as to when we would know.
I mean, because I understand your position, right, is that you would rather do the pilot before we codify this into law. However, we're in a predicament here, because the pilot hasn't been started, even though it is local law. It hasn't been prioritized in several budget cycles now, and there's no assurance that it will be in this budget cycle either. So I don't know that I'm inclined to entertain, right? Because I said the same thing when I saw the bill initially. I said, well, why are we legislating this if we've already passed the local law to create a pilot? Which I'm happy to support, because I agree with you. We need a pilot to better understand what the needs are, how much it's going to cost, what are the nuances. But if there is no assurance that this is going to get funded, and it's not a priority for the administration, then it puts us in a conundrum, because then it appears that we may have to just pass it legislatively, which forces the administration to fund it regardless.
I understand your concern.
Okay. I just have to say that on the record.
I understand.
I get it, that you get it, but I don't think that other people get it. And that for me is very personal. I remember that hearing very vividly, because it actually triggered me. I was married for a long time and in a serious domestic violence situation, and we had separated, and we were separated for many years before I was able to finally get a divorce, because I couldn't afford to do that. And there were no legal services available to families like mine that would help. And I ended up inevitably getting the divorce years later by paying one of those ads that you see on the street, like $4.99 divorce. Yeah, no, it's true. It's $4.99 or $3.99, whatever, for a divorce, and all they offer is really the resources of filling out the paperwork for you that you can then hand over to the court. They stamp it, and then you sign, and it's over. But it separates you from the trauma of that relationship. So that is, so for me, it was really important to be a part of that, to support that. And it really saddens me that we haven't gotten there yet. And I understand, that we have a lot of fiscal responsibilities and have been in turbulent times. However, these are men and women that are stuck in situations that they, whether they want to or not, cannot, that have, serious consequences. If you get, in my case, I was in another relationship. I had 2 children in another relationship. Those 2 children now legally belong to the husband that, abused me, that I'm, that is not the biological father of those children. And, there's a lot that happens. If I want to buy a house, if I die tomorrow, this person can collect, my pension. We should have those resources readily available for folks, and I don't think that is that. I think that when we had the pilot, I think you would have seen that most people don't need extensive legal provider services and, that are gonna take years, but rather they're probably gonna fit into the criteria that I just described of myself, right? That they need somebody to help them fill out, the documents that need to be filed with the court, assuming that they're uncontested, but, okay, we'll also push to make sure that it's a priority on our end, but I will warn you that they're gonna pay for it one way or the other, because they either pay for the pilot or they're gonna have to pay for it legislatively. What, if any, services are currently available to domestic violence survivors going through divorce proceedings who are DSS clients?
Certainly. So individuals who access services, whether it's through DSS or through NGBV, as we both have contracts and providers who provide services in the community, individuals who indicate that they may need legal assistance, including with divorce proceedings, right, will be connected to nonprofits in the community who do provide those services to determine, and assist them in any ways that they can. So folks are referred, right, because through whether it's the DV shelter system, right, our non-residential programs or the family justice centers, right, there will be a comprehensive intake done to understand the specific issues the individuals are facing and that they maybe need assistance with. So individuals who do need legal assistance, including with divorce proceedings, right, are referred to providers in the community who do help people with this work.
But you don't track that, do you?
I do not have that information in detail. The majority of these services are overseen by the State Office of Child and Family Services, and much of the direct communication about services are in between them, and providers are not required to report to us in that type of detail those level of services as the individuals who hold the contracts.
I mean, I get it, but I think sometimes we hide behind this confidentiality clause to be able to share even the most mundane, information. Like, this information that you can share without sharing, and putting anybody's safety at risk. Of the DSS clients, do you know how many individuals seeking services also require support on filing an order of protection against a perpetrator?
I do not have that level of detail, as that is not reported into us.
Are there any additional services that are offered in collaboration with legal services to support survivors of domestic violence while their case is going through the court system? And if so, what are they?
As I mentioned before, right, individuals who need legal supports would be referred to legal service providers and CBOs in the community to assist them. Obviously, individuals, who are in a DV shelter who are experiencing that, right, they would be provided other wraparound supports by the shelter, which I'm sure would include, and checking in with them on how things are going, and if they need assistance trying to navigate, an external referral or system, they would provide that.
But DSS would only collect that information if a person is entering a domestic violence shelter setting, where it would be pretty obvious. But if a person is coming into, let's say, HRA, would they have to self-disclose, or is there a question that is asked? Is there this part of the interview process that offers additional services?
Right. I mean, as part of, for individuals accessing our domestic violence related services specifically, there are intakes, right, that do ask comprehensive questions of individuals as to, the specific situation, their, priority concerns, fears, what might they need assistance with. Mm-hmm. Someone accessing a non-DV related service, those level of questions, right, to that detail would not be, that there wouldn't be that level of detail. But I will say someone applying for cash assistance, as part of it, right, as part of that, there are a few questions that would indicate if someone is experiencing domestic violence and needs a referral to a domestic violence liaison that we have, that could then speak to someone in more depth to understand, like, what's going on, often as it relates to cash assistance and such. If there's related child support that is due, we would want to do some liaising so as to not inadvertently put someone at risk or, reveal any information. So those are ways in which individuals could be connected to other domestic violence services we offer. Okay.
I mean, I think, wherever we can kind of squeeze in those questions, because people won't voluntarily self-disclose all of the time. Yes. And sometimes, we see that in domestic violence situations, victims are reluctant to kind of,
Yes.
go to a provider for fear of, retribution by their aggressor. OMB provided a cost estimate of 12,700,000 for this bill in order to contract with nonprofit legal service providers. Can you provide a more detailed breakdown of the $12.7 million cost?
Additionally, I'll need to follow up with more detail on the 12.7.
Okay. And can you tell us if HRA, does HRA estimate how many nonprofit legal service providers will be contracted in relation to the bill?
We have not estimated that in regards to really understanding also within the community how many providers would actually be interested and also have the facility to do this work. So that is something that, through the procurement process, we would start to understand, right? Providers. We know of some providers who do this specific type of work, but the level to which others might want to enter into the line of work, we do not know.
Okay. I'm going to move on to the intro 1208. In relation to a report on air conditioning in homeless shelters. How many shelters in New York City currently have air conditioners, and how many of these are city owned and operated?
Approximately 55% of all shelters across the system have air conditioner units in their sites. We can get back to you on sort of how that breaks down across families with children, single adults, and adult families, but that is approximately that. And then another 44% have either a cooling space and or fans on in those locations, but they don't have air conditioning units in the sites.
There would be a fan in the unit.
Yeah, there would be fans provided to individuals within the unit, plus a specific cooling space within the facility for individuals to go during specifically hot times. Additionally, we make sure that all shelters and all residents within the shelters have a list of all local cooling centers, both indoors and outdoor centers, for those places for them to go. We are happy with the new addendum that we've put out so that all future traditional shelters will have air conditioning in them as we begin the process of really shifting the system. But obviously the system is built up over decades, and some of the much older sites also have limited capacity to be able to manage air conditioning due to electricity or other factors within the building, but we do believe this addendum is a step in the right direction to really shifting the overall system to have air conditioning available in a wider number of shelters.
Okay. Do you know of the shelters with air conditioners, how many and what percent are family shelters?
It is consistent. I think it is approximately 50%, but we can get back to you with
15?
50.
Oh, 50%.
But we'll get back to you to confirm that.
Okay. What is the process for monitoring and repairing air conditioners?
So minor or standard repairs are managed by the providers, and they do not report that into us, as that is just part of the standard maintenance they should be doing within their shelters. Larger scale HVAC concerns that really impact the operation of the shelter and the safety of residents are reported into us, and we do track those. But the system is so broad, and we don't have a centralized air conditioning tracking system. So many of the repairs would be done through the normal course of the provider.
Are you aware of any cases where a family or an individual has reported that they didn't have air conditioning or a fan?
I do not have that information here with me today. I don't have anything reported. I will check with DHS, but there is standard avenues for individuals to report issues into us through our ombudsman's office and others. So we could check to see if there was any indication, of someone not getting what they should have in that particular shelter.
Yeah. So in July of 24, the New York Times released an article discussing homeless shelters in New York City requiring doctor's notes for families to receive a room with air conditioning. The article highlights a family in the Bronx who complied with the rule, attained a doctor's note, and still did not receive an air-conditioned room until the end of the summer. What is the policy on determining whether a family can have air conditioning in their room? And is a doctor's note still a prerequisite to receive a room with an air conditioning in New York City?
So there is in DHS a standard reasonable accommodation process that individuals can submit a reasonable accommodation. Having an air conditioner unit is one such request individuals could request based upon a disability or medical need. As part of that, they would need to submit some type of medical documentation that speaks to the reason they would need an air conditioner in their unit or a unit with an air conditioner.
And assuming that the reasonable accommodation was granted, would the person receive an air conditioning to install in the existing unit that they're in, or would they have to be transferred out to a building that provides that service already?
It would depend on case by case, depending on what particular shelter the family was in at that point. So if it was obviously we would love to accommodate people where they are and keep them where they are, especially families. But if they are in a shelter that maybe couldn't maintain an air conditioner due to electrical wiring or something like that, the family would likely need to be relocated. We would obviously work to minimize the disruption of the relocation. So hopefully to, another shelter if that was needed within the area in which they currently are, would definitely be a priority for DHS.
Has DHS considered maybe allowing residents to be able to purchase and bring in their own air conditioning?
We have not, that is not something, right, for individuals to individually do that. That is not something, given sort of the whole of the building approach we need to take in regards to the shelters. But, individuals who do need it for a reasonable accommodation, request, we do encourage them to do that. And, we hope with the new addendum that more and more shelters will come on that provide air conditioning to residents in our shelters.
But what concerns you about, what is the reason behind DHS's reluctance to allow folks to bring in their own air conditioning units? Because I'm pretty sure that there are families that cannot afford it and maybe don't have that level of support. But there are families that do, right? That may be able to donate, a new air conditioning unit. What would be the rationale for denying them that?
I think there are a variety of factors in regards to installation of the units and ensuring that they're installed correctly, as I don't believe we would really want individuals to install the units on their own. It really also depends on, what is the building and what can the building take and what can it not take, are some of the key factors. But we can get back to you with some additional factors that, might be of concern there, and any other regulations that might guide what individual families are able to bring into their units, or not bring into their units, as over time units will transition between families and individuals who need them.
Starting tomorrow, we're going to be entering a serious heat wave, and with climate change, that is becoming more and more common. I cannot sleep if I'm hot. There's no way I'm going to be able to sleep. And if a person has a respiratory issue and they haven't yet, been able to get to a doctor and having to sleep like that or live like that in a space. And I get that the common areas are available, but I'm sure that, they aren't as accommodating as they could be for individuals to sleep through the night if they needed it. So I would love to see some sort of data on the conditions in the buildings that you contract with that would prohibit families from being able to buy their own equipment. And I've heard many reasons. I don't want to, I don't want to get into that and, share misinformation on what that is. But I think that is a more cost-effective way. There's to do that, and I think that it would really go a long way. How long does it take on average for families who have a doctor's note or other proof of need of a reasonable accommodation to be moved to an air-conditioned room or unit?
I will have to get back to you with that information. I think it can depend based upon, if a unit needs to be installed, that is probably something that could happen relatively quicker than if we needed to relocate the family. But we can get back to you with, on average, how long does it take?
Okay. Do you know how many shelters in New York City do not have air conditioning in every room?
So that would be approximately 44% of the shelter system. There are over 400 shelters.
Okay. And has the city created a plan to ensure that families in New York City systems are not sleeping in rooms without air conditioning during extreme heat temperatures?
So we do have, right, during periods of time where there is an extreme heat, right, we do have our code red procedures, and, you know, we'll work with families, right, to have them go to cooling, right, if they don't have an air conditioner, to the cooling room, having fans in their room, to address, you know, how to help them through that period of time, as well as connecting them to local cooling centers.
Again, cooling centers are only open to a certain amount of time. Okay, I'm moving on to resolution 362, calling on the New York State Legislature to pass and the governor to sign A.5291 -7, I'm sorry, S.5975, the Social Worker Workforce Act. Social workers make up what percentage of the social service employees employed by DHS in New York City?
So there are, but across DSS, HRA, DHS, there are 90 social workers, which is 0.7% of the 13,243 employees we have. A large bulk of our employees, right, are benefit and eligibility specialists, which is the key social service we provide. We also have caseworkers who provide supportive case management and other activities. So I just don't want it to seem as if, right, social workers are the only title that provides these services. Obviously, in the case of DHS as well, a majority of their services are provided by nonprofit vendors who have their own staff who, you know, provide mental health supports and other supportive supports to residents.
I mean, that number seems pretty minimal to me, considering the type of services that DSS provides. And I get it, right? We all have to kind of pivot depending on how much funds are coming in. So we hire, you know, caseworkers that are not, but they have to have a certain level of experience, right? That social workers bring to, you know, to the table. Being able to recognize mental health disorders, being able to identify domestic violence, being able to provide, you know, the level of information and care that each individual, right, in need of services is entitled to, should be entitled to, is difficult when we are, because of fiscal, you know, matters, not hiring the appropriate staff, right? So that is where it kind of.
Right. I would say the services we have where the level of service and support needed is through a licensed social worker. A majority of those services are provided by actually nonprofit vendors. So through our DV system, that is, you know, done through providers, the DHS system through providers. So, you know, and then obviously we do have some social workers through some programs that are not provider driven or operated. But so I would say that there are, you know, people do access those services. Oftentimes they're accessing them through a nonprofit that we've contracted with rather than those services
does a nonprofit
directly.
contract, does a nonprofit contract require that the organization have a social worker on staff?
So depending on the specific contract, yes, there will be staffing requirements, right, as related to what type of staff are required and expected through the provision of those services. And so depending on the service, we will identify, right, where there are expectations around social workers or other like licensed clinical mental health. That will vary across programs depending on what the program needs, but that would be part of the scope and expectation for providers, depending on the service that they're providing, to have access to those types of individuals with that type of training.
So the 0.7% is basically just under the purview of the administration, your
Just
agency.
city staff. So it would be a city staff civil service title. Yes, we can get back to you with estimates around what, you know, within the provider community who provides our services, where they are, but there is, so I do want to make sure everyone knows that, like, we are providing access to social workers. Much of that is going to be done through a nonprofit rather than directly through a city worker.
I mean, I'll tell you, there's no way you can convince me that I'm not a social worker, and I'm not.
Yep.
I'm not, right? But I was trained by some of the best social workers, and I picked up a lot of really valuable information, so I'm actually really good. But I can tell you that there's a very clear distinction between, what social work, the level of services that social workers are trained to do, based on somebody that we're hiring that has good intentions and maybe, is familiar with some of the issues that, that impact our communities. I'm not insinuating that service is not, is not great, but there is a difference. There's a really big difference. When I started working, my first job out of college was at a senior center, and we had so many people coming in to the center that visibly had serious mental health issues. Like, I mean, they were waiting for me outside praying in the middle of the street, blessing cars. I had one that, I mean, I could go on and on, on the issues, and nobody was there. I mean, they had been there for years and nobody recognized that in them. And so my supervisor, used to say, they weren't here before you got here, but I'm like, they were here, just we didn't have the experience staff, right, to pick up on if a person is repeating themselves, right? It may be that they're starting to get dementia, but it could also be a medication issue. It could also, it could be so many different things. And as social workers are trained to be able to identify those issues. So they are a really critical part of the social services, umbrella. And, so whatever you can do to get me
completely
that
agree
number.
with you. I too worked in aging before I came to the city, or worked for Sage, and understand the real importance of social workers and what they bring to it and how they can really work with individuals to identify what needs they may have.
Is there any way for you to track how many licensed social worker candidates pass the licensing exam on the first try?
That is not some information we would have on that. That would really be information I think the licensing board would probably need to provide.
Okay. All right. Moving on to Reso 0839, calling on the New York State Legislature to pass on the governor to sign A03578 /SO 00403 to establish a SNAP and cash assistance fraud victims compensation fund. Do we know how many New York City residents have been impacted by SNAP and cash assistance fraud this calendar year and in 2024?
So I can report how many claims have been filed, which would be a proxy, but I will say, given that the ability to reimburse for SNAP federal benefits ended at the end of December, this is definitely going to be an undercount, as individuals would have not submitted a claim given they were not able to. But total claims filed, so for cash assistance, for this year, it's been, so far to date, it's been 12,476. In the prior calendar year, 2024, it was 35,312. For SNAP, so far this year, it's been 22,538 claims filed. Last year, it was 86,232.
Do you know what that amounts to in total benefits that was stolen?
Yes, so total report stolen. So cash assistance for this year so far, the reported stolen was approximately $3.1 million. In 2024, it would have been approximately $8.6 million. For SNAP, so far this year, it's approximately $11.7 million. And last year, it was $42.3 million.
I think it would be more cost effective for the state to just create the chipped card, and we can all be done.
Agree with you that the chip card is the way to go. I know there's two bills at the state level, which, similar to this reso, will now have to wait until they come back. But it is something that we continuously advocate for as well, in regards to the way to really address this is to utilize modern technology.
Okay. All right, Administrator French, thank you so much for being here today. It's always a pleasure to have you. And we look forward to getting the responses to the questions that we weren't able to get a response to. Thank you.
Thank you very much.
All right, we're going to take a very quick 5-minute bathroom break, and then we will start. All right, we're back. I now open the hearing for public testimony. I remind members of the public that this is a government proceeding and that decorum shall be observed at all times. As such, members of the public shall remain silent at all times. The witness table is reserved for people who wish to testify. No video recording or photography is allowed from the witness table. Furthermore, members of the public may not present video or video recordings as testimony, but may submit transcripts of such recordings to the Sergeant of Arms for inclusion into the hearing record. If you wish to speak at today's hearing, please fill out an appearance card with the Sergeant at Arms and wait to be recognized. When recognized, you will have 3 minutes to speak on the legislation being heard at today's hearing. If you have a written statement or additional written testimony that you wish to submit for the record, please provide a copy of that testimony to the Sergeant at Arms. You may also email testimony to testimony@council.nyc.gov within 72 hours of this hearing. Audio and video recordings will not be accepted. We will now call up the first panel. Noam Cohen, Carla Aguilar, Calvin Michael, and Diana Ramos. You may begin. You can start. Go ahead. You can begin.
Yeah. Thank you, everybody, for being here today. My name is Noam Cohen. I'm a proud member and leader in Vocal New York's Homelessness Union. Here at Vocal, we directly organize people who are directly impacted by homelessness and fight for what our communities need. I currently live in a shelter run by Canva, and I've been living there for over 1.5 years now. For almost 2 weeks now, we've had no AC in my room. There's a large room in which this is a large room in which I have 22 roommates. The venting in the building is so poorly designed that the vents on the ceiling don't even work at all. Several months ago, with the Callahan inspection approaching, they installed a temporary fix for the heating by installing a single ceiling fixture in the middle of the room. That fixture no longer works now. Right now, we only have 2 electric fans for the entire room. At first, they only put in 1 small fan on my side of the room, a very loud industrial run that makes it very hard to sleep. I tried putting in foam earplugs. Those ended up hurting my ears. I was not going to do that for too long. Can't really afford noise-canceling headphones now. When we asked our shelter director what the plan was or what date they could fix this by, we didn't really get any answers. We didn't get no plan. We didn't get no plan to fix it by. You know, I think it's worth noting, we have elderly people in my shelter. We have people with disabilities in my shelter. People who are being put at serious risk of heat-related health issues. This is all because shelters are failing to meet a basic human need, a safe and livable environment. The bill proposed by Councilwoman Gutierrez would require that city agencies put out reports on the status of AC in the shelters 12 months, 1 year after its passage. I'm really here to say that's not adequate. All you need to do, this is an urgent issue, and it's really concerning to me that this isn't really being treated with the urgency it deserves. All you need to do to find out whether the hundreds of shelters in New York City have proper ventilation, proper heat, proper AC, is to really simply talk to the people inside. We need enforcement mechanisms. We need hefty fines when you find that a shelter is either refusing to turn on the AC and heat or refusing to repair it. And when it comes to shelters that don't have AC at all, there shouldn't be shelters that don't have AC or heat at all. These are basic human rights that we're talking about, and this should be treated with the urgency it deserves.
Can you pass the mic? Yes, thank you. Make sure that the light is red.
Good afternoon. My name is Diana Ramos. I am a member of the Safety Net Activists, a part of the Safety Net Project. I am here to give testimony about the need for a recovery fund for benefit recipients who have had their benefits skimmed. This month, I was a victim of my SNAP benefits being skimmed straight off my card. June 4th, I received my SNAP. By 2:46 a.m. that morning, while I was asleep, they were stolen off my card. I am very mindful and careful with where I use my benefits. I never give others my PIN number. I only use my card at businesses I trust or big corporate stores. I have changed my PIN every 3 months, and I have even downloaded the recommended app that would allow me to lock my card and keep track of all transactions. That still didn't prevent my SNAP benefits from being skimmed in 3 separate transactions from Buffalo, Eastchester, and Staten Island. I didn't find out till 4 p.m. that afternoon. I immediately took action and I replaced my card. I reported my card stolen and received a replacement. I notified my advocate at Safety Net, Adriana Mendoza, and the 3 organizers I frequently work with on various campaigns. I suffered a severe panic attack because I didn't know at that moment what I was going to do for food for the month. I am a diabetic, and I have a certain eating plan I follow to keep me in good health. I also suffer from heat sensitivity, which makes standing in line at food banks dangerous. I get SSI, and after paying my bills, I have very little left over to cover a month of food. Thousands of New Yorkers have been robbed with no way of recovering what was stolen from them. New Yorkers on benefits feel abandoned by the state. Many children, elderly, and disabled New Yorkers are starving because there's not a way for them to recover funds or even obtain nutritious food. I got very lucky this month, and because of the situation, was able to get a food grant from Safety Net to get my groceries. HRA would have done nothing. There are 2 solutions that would not only combat this problem, but also help New Yorkers recover what was stolen. Solution 1 is Resolution 0839, which calls on the state legislature to pass and the governor to sign A03578 S00403 that would establish a compensation fund for victims of benefits fraud. The second solution is to have chip cards, which have been proven to be more secure than the current cards. There are many states switching to chip cards, including New Jersey. These 2 solutions together would not only keep New Yorkers' benefits safer, but also help those who have had their benefits stolen. I thank you for allowing me to speak.
All right. Use this one?
Yes, just make sure that the light is red.
Okay. Good afternoon. My name is Calvin Michael. I'm speaking to you on behalf of the Safety Net Activist Group in conjunction with the Urban Justice Center. The main focus and topic of my testimony this afternoon is because of a distribution of New York City shelters that do not have air conditioning, and I'm specifically speaking about that. And I would not be speaking on this if I didn't have intimate knowledge and reality with the situation, because I was at Clark Thomas Men's Shelter, which had no AC. 300 men on an open floor, no AC for the 3 years that I was there. Okay, so 4 in 10 NYC shelters have no AC in sleeping areas. According to the New York City paper, The Gothamist, there seems to be quite a large number of clients who are without proper climate control for their giving areas. I spent my entire tenure at Clark Thomas Men's Shelter on Randall's Island, Ward's Island, without air conditioning. May I also mention that the facility had 300 men, yes, on an open floor, no AC. What was provided in lieu of air conditioning were several industrial fans that were installed on the walls. Air conditioning in homeless shelters is just about comfort, it's about preventing heat-related illnesses, protecting basic human dignity, and ensuring that folks have what they need to stay cool and healthy. I would also like to comment on the related health risks that are associated with not having sufficient air conditioning in close to half of New York City shelters and the hazard that it creates. Some people are at higher risk of getting sick from heat than others. There are unnecessary risks for people, or unnecessary risks for people, for example, who take medications that make it hard for them to properly regulate their body temperature. Hot days can be dangerous for anyone, but it can be especially dangerous for those who have chronic medical conditions such as and create uncomfortable situations for those who have symptoms like diseases like asthma and multiple sclerosis can also create huge difficulties for them. Some of the heat-related symptoms are muscle cramps, headaches, nausea, and vomiting. I can relate and emphasize with this personal experience of my former shelter mates, being in an environment where 110 degrees, were hot and sweaty and angry. Fights erupted in the shelter every 20 minutes in July and August, and it didn't matter which month it was. Some of the current residents can experience temperatures in the summer that can be quite unbearable. Temperatures are about to ramp up in New York City right now. Many people, including in these shelters I stayed in, will experience them without any air conditioners. Safety Net is strongly opposed to the lack of air conditioning in existing shelters and proposed that the Department of Homeless Services appropriately address the lack of air conditioning across 50% of New York City shelter population. While we are glad this issue is being discussed, we also need to make sure that there's a report made. We call on the council to pass legislation to create a solution to the problem by requiring DHS to install air conditioners in New York City shelters. I will leave you with this. People die every year because of the heat. People in shelters have higher rates of disability, much higher than the general public, making them even more vulnerable to the heat. We ask the Department of Homeless Services use whatever financial resources are available to provide air conditioning, for example, for existing clients in the New York City shelters, and that New York City Council required them to do so. Especially, thank you, Councilman Iola, for having me speak. One thing I want to end with, I'm very grateful for what they're doing for the air conditioning shelter. As a shelter resident, I'm grateful for the help that you've been giving to us, especially as an activist. So my gratefulness is just unending. Thank you very much.
Good afternoon. My name is Carla Aguilar, and I recently earned my MSW from NYU Silver School of Social Work. I'm here in strong support of the Social Work Workforce Act. While getting my MSW, I completed thousands of hours supporting some of the most vulnerable people in our system, recently migrated teenagers in the foster care system, and cancer patients in one of NYC's medical facilities. I've built trust with people in crisis, helped families navigate systems stacked against them, and now I can't even get hired. I have been constantly told I'm overqualified for jobs that don't require an LMSW and not qualified for the ones that do. All because I haven't been able to schedule a licensing exam that has nothing to do with how we actually practice social work and everything to do with who can afford the time, money, and mental capacity to pass a biased exclusionary test. My partner was recently hospitalized in a psychiatric unit, not just from a mental health crisis, but from the cumulative weight of financial instability, much of it stemming from me not being able to find stable work after graduating. I have the training, I have the skills, but I'm locked out, and so is my entire household. My father, a 63-year-old cancer survivor, still works every single day and helps us cover groceries. This is what it means to be a social worker from a working-class first-generation background. We care for everyone else while barely surviving ourselves. We're told that this profession is about justice. But what justice is there in a licensing system that systematically excludes people like me? People who speak the languages of our communities, who carry lived experience, and who are deeply ready to do this work. The Social Work Workforce Act is a step towards repairing that injustice. It removes an unnecessary and harmful barrier and allows states to license us based on what actually matters: our training, our ethics, and our practice. We're not asking for a shortcut. We're asking to serve the communities we've already been showing up for with dignity, with stability, and with the chance to finally make a living doing the work we're trained to do. Please support the Social Work Workforce Act. Thank you.
Thank you. Thank you for coming to testify and really raising some of the concerns that really highlight why it's important that we pass these bills. I have a question for Mr. Cohen. Mr. Cohen, you said that you had no AC, but they put in 2 fans, but those are the industrial fans?
Yeah, I'm referring to 2 industrial fans, electric fans plugged into an outlet
And how many people were in the room?
with an extension cord.
How many people were in the room?
23 including me. I have 22 roommates.
Okay. Have you asked, has anybody in the room that you know of asked for a reasonable accommodation?
Yes, I've asked them to fix the AC. I don't know about a reasonable accommodation, but
Yeah, no, so a reasonable accommodation would be a request to say I have asthma or a respiratory issue that requires that I have air conditioning?
no, I don't believe I have that. That's the thing.
No, not you, but
yeah,
I'm saying
right,
the folks
yeah.
that are in the room. Are you aware of anyone that has any of those issues?
I'm aware of people with health conditions that make them averse to heat, or to high temperatures. Yeah.
I appreciate that. Okay.
Yeah.
And during the daytime, is there a space, a cooling space that you can go to?
There is a room downstairs that has working AC.
Okay, and it has chairs for you
Right, but not in the sleeping areas. That's really the issue right now.
Yes. Okay. Thank you for that. Ms. Ramos, did HRA ever refer you to any programs, or how did you become familiar with the Safety Net project? And did that referral come from HRA, or did they recommend? Because I'm trying to figure out if there's a process, and I brought it up at a couple of hearings prior to this, where when a person is reporting that their benefits were stolen, that they're automatically granted information on programs and services that can be helpful, right? Like food pantries, nonprofit organizations that are offer some sort of grant. Is that something that you've heard of, or were you just coincidentally connected to the Safety Net program?
I am actually part of the membership of the Safety Net activists, and so that's how I say I was lucky. There's not very many people like myself who are connected, and Adriana Mendoza, my advocate through Safety Net, who has helped me with the loveliness that is HRA so many times. Bless her. She was the one that was able to connect me to get the food grant. And we had talked about me talking to HRA, and I was basically told that they would tell me just to food banks and whatnot. But as I said, I am heat sensitive. I have heat sensitivity. And if it was in the fall, when they sort of screwed up my food stamps in September, it was a little easier. It was cooler. As it's getting hotter, I have to be careful. I've already been in the hospital once because of my heat sensitivity. And that is not something I want to do. I mean, I have a dog at home. She's my baby. And just there's just too much to do. It's bad enough that my apartment gets really hot. So, you know, HRA would have done nothing. In truth. And I don't even think, I probably would have had to call 311 in order to get any connection to any possible food banks and things of that nature. As I said, I'm just lucky that I am part of Safety Net, but there's so many others who aren't, and it's my neighbors too. Yeah, I'm just one, and I mean, in my building, I think I'm going to say about 30% of my neighbors, single and with families, have had their benefits taken. One, a mother of 4, who had, I think it was a total of $900 taken from her SNAP benefits.
Yeah, no, we've seen a lot of that. We have seen a lot of that. But so when you called into HRA to report that the benefits were stolen, there was nothing.
I just reported my card stolen,
but they didn't,
and just got a replacement, and that's it. Through the number that they told, because they tell you, you know, if this has happened, you know, you got to replace your card first. As far as trying to contact HRA on my own, I really did not have the mental capacity to wait 5 hours to be either hung up on or talk to someone who would just give me the answer if there's nothing we can do for you.
No, it's important. I'm trying to gauge what level of information is going out in cases where cards are, you know, benefits are stolen, to ensure that folks are not going without,
the information I got was from my advocate, who understands my heat sensitivity issues. I do know of some food banks and stuff, but you have to stand out there for hours if you want to at least get something. I'm a diabetic. I have to eat higher protein. There's certain processed foods I shouldn't be eating all the time. Every once in a while, if you get a hankering, it's fine. But to do that for a month, even before I was able to get the grocery order, in that week or whatever, I mean, I'm feeling it. My numbers are all off. You know, I have to now hit eating windows because my sugar will drop suddenly, and then I have to be careful what I eat. It's a whole process. Especially, you know, and then having fibromyalgia, I can't eat certain foods that exacerbates inflammation. It's a yay moment. But having a fun to be able to say, hey, this is what happened. I mean, I'm sorry, Buffalo's 9 hours away. Last time I checked, the Super Price Chopper's not open at 2:45 in the morning, but yet they managed to take $92. Yeah. And then, you know, and Eastchester and Staten Island. These are places I've never been. And Staten Island I've been, but I never bought anything.
Mm-hmm. No, it's awful. But I appreciate you coming in to, you know, share your experience with us. Thank you guys so much for coming in. Carla, you should speak. You have a whole bunch of social workers back there. Get the hookup. Thank you all. Next panel, Laura Russell, Rachel Brownstein, Deborah Berkman, and Raji Ida Yatung Mangalam. Whichever corner wants to start first, you can feel free. Just make sure that the red button is on.
Thank you. I'm Laura Russell, the Citywide Director of the Family Domestic Violence Unit at the Legal Aid Society. I'm speaking in support of Bill 1175. The Legal Aid Society is the nation's oldest and largest legal services and social services organization. The Society civil practice, of which I am part, provides comprehensive legal assistance in a broad variety of legal matters, representing litigants in most courts within New York City. The Family Domestic Violence Unit represents litigants in both family and Supreme Court in an array of family law and matrimonial matters with a focus on divorces for domestic violence survivors. Our staff, housed in each of the 5 boroughs, specializes in handling complex divorces. The Legal Aid Society is grateful for your recognition of the need for representation in divorces for domestic violence survivors. As you are aware, there is no right to counsel for financial matters of a divorce or in the actual filing of a divorce itself. Divorces are complicated, Supreme Court is not user-friendly, and the paperwork can easily overwhelm a survivor. In an uncontested divorce, the simplest divorce, you might have to file 25 separate documents before you can get divorced. Contested divorces are even more complicated, sometimes taking years to complete and multiple court appearances. Furthermore, as many domestic violence survivors are also survivors of economic abuse, these divorces become even more complicated as assets and income have been hidden from the survivor, and assets are not in the name of the survivor. Divorces are expensive, even for those with means. Litigants state that they've wiped out college fund, bank accounts, and even retirement assets to afford representation. Low-income litigants have none of this and resort to going alone in court. Without representation, survivors give up much-needed assets. In a divorce, issues such as rent-controlled apartments, child and spousal support, and even retirement accounts are decided. Survivors are often fearful to go to court alone, will waive these either to stay safe or because they do not know what they are entitled to. They become homeless, lose substantial retirement benefits, or even forced on public benefits because they're not able to secure support and the assets they deserve. This legislation will allow survivors to have representation where they are seeking what they deserve, their share of marital assets, support, and a divorce. The Legal Aid Society, together with the New York Legal Assistance Group, has applied for funds utilizing Local Law 5 of 2002 to create a pilot project to assist low-income survivors in divorce, just as this legislation has proposed. I did hear HRA's testimony, and I would like to say that we are seeking for a pilot project $1.9 million, a substantial amount less than what HRA claims a pilot project would cost. And furthermore, we extrapolated the data as to how many divorces would exist from the already existing data that the Office of Court Administration puts out almost annually on divorces. Some of the data that HRA asked for, may I continue? Some of the data that HRA asked for does not exist because the Office of Court Administration does not collect it. I ask that you push forward this bill regardless of the fact that some of this data does not exist, because you can extrapolate from the data that does exist much of the numbers that would be needed for support and for how much it would cost for a pilot project for divorces for domestic violence survivors. In the proposal that we mentioned, we also stated that we would look at representing litigants who are 200% or below of the poverty guidelines, looking, of course, at just the income that the domestic violence survivor has, not the income of the marriage, noting that it is impossible to, with the income of the marriage, for the lawyers to be paid from the other side. So therefore, we're looking at just the domestic violence survivor. Both us and NILAG have done this jointly, and we've put this forward for 2 years, and it has unfortunately not been funded to date. So I do ask your consideration in reviewing that, reviewing the data in that, and reviewing the numbers. Finally, a divorce is a final step in the process of being free from abuse. Survivors need representation to be free from abuse. This legislation will provide them with this needed piece to be free, and that is why the Legal Aid Society supports this essential legislation. Thank you.
Good afternoon. Thank you for the opportunity to testify. My name is Rachel Bronstein. I'm the Director of Policy at Her Justice, a nonprofit organization that has advocated with and for women living in poverty in New York City for more than 30 years. The Council has long supported Her Justice in our work on behalf of women living in poverty, and we thank the Council for recognizing the need for more resources through this Proposal 1175. We're grateful for the opportunity to raise some additional considerations for making the proposal as effective and sensitive to the needs of survivors as possible. The proposal recognizes that there is a civil justice gap in divorce, a critical life-altering legal process for many. Given the significant legal need for domestic violence survivors and the resources required for effective representation, we propose that the Council move forward with implementing a fully funded pilot program in partnership with expert legal services organizations and leverage the pilot to evaluate the most effective way to expand legal services for survivors in divorce. A fully funded pilot program would support legal services organizations with expertise and a proven track record of effectively serving survivors. Her Justice and our pro bono partners in the city provide legal representation to clients, including survivors of domestic violence, in both uncontested and contested divorces. Legal representation in all divorce cases requires expertise and time. Contested divorces are inherently high stakes and typically last months, if not years. Generally, legal representation in these complex cases can be incredibly costly, and for many it is simply unaffordable. Research shows that the average cost of divorce in New York is substantial, at an overall average of $13,800, rising to nearly $19,000 for cases involving children, and the figure may be far higher. Many Her Justice matrimonial clients are those who have experienced domestic violence. In 1 year period, we had 69% of our matrimonial clients reporting domestic violence in their marriage, with the divorce being a critical moment for them in their journeys. Divorce can be complicated for DV survivors in custody and visitation, in seeking orders of protection, and because they suffer economic abuse, leading to, among other things, coerced debt or non-consensual credit-related transactions that occur as a result of coercion or fraud. Complex legal issues require the services of expert counsel. Her Justice and the organizations here provide extensive and knowledgeable legal representation to survivors and, along with legal representation, essential other services, including, as we do, running credit reports for our family and matrimonial clients to identify additional financial services they may need. The pilot should encourage and fund partnerships with organizations with holistic and trauma-informed service models and lawyers who are cross-trained to understand systemic barriers that complicate survivors' needs. If I may just quickly point out on the topic of data, we think this is an opportunity, this pilot, as proposed, to assess the extent of need and resources for divorce representation. There is a data gap, as my colleague pointed out, around the needs of survivors in divorce, the prevalence of domestic violence in divorce cases, the experience and outcomes for survivors in divorce, an investment in collecting and reporting on court data, in addition to the knowledge and expertise of legal services organizations long providing services, would be valuable to understanding how best to expand services through this proposal for those in need in the city. Thank you so much.
Good afternoon, Deputy Speaker Ayala, council members, staff. Thank you very much for the opportunity to speak today. My name is Deborah Berkman, and I'm the director of the Shelter and Economic Stability Project at the New York Legal Assistance Group, or NYLEG. Now, I have prepared remarks, but before I get started, I just want to answer one question that you had asked the representative from DSS who was here earlier today, and you said, why is the one-shot deal acceptance rate only 28%? And one of the things that he didn't say is, but which so many of my clients struggle with, is the interview. The interview, so there's two components. One component is that people don't know that they have to spontaneously call for an interview. It does say it in very small print at the end of the application, but there's no sort of warning that says your application will not be processed unless you call in. And that's actually what happens. And then the second part is that when people call in, the wait time for the interview is so long, and people have jobs, people are working, there are so many reasons that they can't spend 5 hours on hold. So, just as an aside, I want to start by saying NYLEG enthusiastically supports Intro 1208, which mandates reporting on the availability of air conditioning and shelter. And it's no surprise to the council that New York City experiences extreme heat during the summer, and those temperatures are rising due to climate change. In fact, each summer, more than 500 New Yorkers die as a result of extreme heat. And unsurprisingly, these deaths don't fall evenly across racial lines. Black New Yorkers are more than twice as likely to die from heat stress than white New Yorkers. According to the New York City's Mayor's Office of Climate and Environmental Justice, lack of access to home air conditioning is the most important risk factor to heat stress death. Clearly, access to cooling is essential for summer safety. Many New York shelters lack air conditioning, and we just heard about the experiences on the last panel. My clients consistently report stifling conditions that make it unbearable to sleep at night. These conditions are often worsened by sealed windows and a lack of fans or other cooling devices. And in some cases, my clients are forced into street homelessness during the summer because the shelter conditions are so oppressive inside. This bill is an essential first step towards providing New Yorkers experiencing homelessness with safe, livable environments during the summer. But NILAG also urges this council to pass this legislation and to take next steps and mandate that all shelters provide air conditioning and allocate funding to bring older shelters in compliance. And there will be funding needed because there are some older buildings that won't easily support the infrastructure. Also, my colleagues in the Domestic Violence Law Unit have prepped me on this issue, and regarding Intro 1175, NILAG commends this council for considering additional funding to provide legal assistance to domestic violence survivors seeking to separate and divorce from their abusers. However, we urge careful consideration and further research before moving towards practical implementation. Just very quickly, we recommend that this council implement the pilot project that was proposed by the Legal Aid Society and NILAG to start with the one borough approach and see where we go from there. And because it's important to start with the pilot project because these cases do differ significantly from those addressed in other right to counsel programs. And just finally, NILAG gets so many SNAP skimming cases and cash assistance skimming cases. And since there was a time that those benefits could be replaced for SNAP, and now they cannot, and so many of our clients have nowhere to turn, they don't know about the Safety Net Assistance Program when the money that they rely on for food is suddenly gone. This particularly impacts our elderly clients. So we very much urge this council to pass Resolution 839. Thank you.
Good afternoon. Thank you, Deputy Speaker and Chair Ayala, and thank you to the staff and council members on the Committee of General Welfare for holding this timely hearing on the fractured supportive housing process. I would like to take a second to thank you, Chair Ayala, for recognizing on behalf of all of the social workers on the front line the work that we do in various areas that are interlinked to one another. Prior to, I'm Raji Idiathmangalam. I'm Senior Policy Social Worker at New York County Defender Services, where I've served about 300 clients cycling in and out of, jails, prisons, the shelter system, and various other institutions. Our office supports Intro 791, and we want to offer a solution to patch or bridge the bewildering bureaucratic chaos and fragmentation that we've all heard about and that I've seen alongside clients over and over on the ground. It's basically, as we've heard today, left us on one hand with a surplus of 5,000 or so units, and there's obviously nuances and details to that DSS went over. But then on the other hand, you have people in crisis and with unstable housing or unhoused on the other hand. In 2024, New York County Defender Services served close to 6,000 clients, of which we have data where we realized that more than 1 in 3 clients were unstably housed or unhoused. As raised by the committee already with the example of the one-shot deal, which was also just referenced, the issue is that the right hand doesn't know what the left hand is doing, and so much is left to the individual to navigate on their own. I would liken the supportive housing process to having to go to the DMV, and I did a month ago, close to that, the Real ID deadline. It's like going to the DMV blindfolded over and over again, every week for months on end, with an added twist that every time you're told to start all over again, each time because you didn't do this one task or you didn't bring this other document. And Chair Ayala, you also referenced your own experience in your own life. Such a fractured process has left people like my former client, whom I'm called Kay, spinning his wheels for years amidst his ongoing housing crisis. Kay successfully completed his arduous Manhattan Treatment Court mandate more than 2 years ago. He's been in stable recovery from decades of heroin use. He's been working full-time for a few years now. He's steered clear of any criminal legal contact, but still he has no stable housing. I mean, Kay is every fractured system's poster child. We should all be celebrating him because this is not easy to do, as we all know. He's done everything humanly possible against all odds, and he needs all the help he can get to find secure housing, not in the distant future, but now. I mean, let's talk about all the walls that Kay has faced. He's been unable to access any of the housing options or rental assistance program in the city, be it Section 8, City FEPS, SODA, market rate apartments, or even affordable housing. His successful recovery actually disqualifies him from many of the supportive housing categories that he may have been eligible for earlier while he was in the treatment court. So also, Kay is just one of the thousands of NYCDS clients in this predicament. So I want to wrap up with offering a solution because New York County Defender Services wants to help clients like Kay and others in housing crisis. And in order to do that, we need the necessary funding and staffing infrastructure to provide the specialized benefits and housing navigation services that our clients need. You know, for instance, in the instance of Kay, had our office had such expertise in place, maybe Kay would have been approved for supportive housing while he was already participating in the treatment court. So why is a public defender office so uniquely positioned to close some of these bureaucratic gaps? We work closely with our clients like Kay who have open cases. We work with them throughout their legal case. We build trusting relationships with our clients, and we gather crucial information to assist not only in their legal defense, but some of the information we gather for their legal defense is actually pertinent to their supportive housing application. So rather than send them to 20 other places while we're working with them for a couple of years, we could actually be working with them from day one. So what our office is proposing is, if we got the funding to hire benefits and housing specialists in-house, these specialists would work alongside the legal defense team, and as Chair Ayala, you had alluded before, we would work alongside, the specialists would work alongside the social workers, the defense attorney, and kind of there's going to be a two-pronged approach. Everything goes towards housing, and another goes towards the legal defense. Because we want to do this, and we can do this, so we're actually requesting this kind of help so that we can help our clients. In closing, as with so many New Yorkers in our client case situation, supportive housing is often their only housing option. Dare I say to the committee that the housing crisis our clients grapple with may actually be solved by the timely help of a few and dedicated and skilled specialists who know how to build these stable bridges over fractured processes. I would say let's replace fragmentation with coordination. It's possible, and we can start to begin to end this homelessness. And again, we support the local bill, Intro 791. Thank you for your time, and I'm happy to answer your questions.
Thank you. Thank you for all of the work that you guys do. I know that you are helping many New Yorkers navigate a very complicated system that is not intended to, to make it easy on folks that are already stressed out and, at their wits' end from having to go from one place to the other without any clear clarity on what they're expected to do and who's supposed to call them and follow up. And, it's a lot of work, and I'm hoping, we're hoping that these bills will help simplify some of that and remove some of those barriers to service. But your testimony is critically important because you have that firsthand experience, so appreciate you coming. Thank you. Okay. Our next panel will be, you can go. Allison Wilkie, Jonathan Chung, Luisa Lopez, and Siobhan Naboa. Okay, you may begin.
Start. Hi, my name is Allison Wilkie. I'm the Director of Government Affairs and Strategic Campaigns at the Coalition for the Homeless. Thank you for holding this hearing, Deputy Speaker. So I'm going to talk about intros 1208 and also 791. So last year, 2024, DHS issued 18 code red alerts, and those alerts are when temperatures are so high that they do extra street outreach to bring people indoors to spaces where drop-in centers, other spaces where there is cooling. So it is kind of sadly ironic that not all shelters have air conditioning when they issue these alerts to bring people indoors. According to our data from our monitoring of DHS shelters, and this is since fall 2024, only 48% of shelters for families with children have air conditioning throughout the building. Oh, and I didn't say my name. Oh, I did say my name. Okay. For shelters for adult families during this period, 64% had AC and 76% of adult shelters inspected had air conditioning throughout the building. That's not every shelter, but it's a vast majority that we reach in our inspection cycle. So there's a lot of shelters that don't have AC throughout the building, and it's important to note why it's important that there is AC in all parts of the building, because there may be AC in one room, like a cafeteria or a common room. But what we hear from shelter residents is that they end up then sleeping on the floor of those rooms because that's where they can get AC at night. And then you also are restricted from being in dorm areas during the day, but for people who get a special pass because they have a disability that requires them to rest during the day or because they work like evening hours, that means that they have to be in sleeping areas that don't have air conditioning during the hottest part of the day. And as Calvin and Noam were talking about, homeless New Yorkers have higher rates of disability than the general public. They can have particular hazards and health risks and excessive heat, for example, for people who take medication that causes dehydration or makes them more prone to heat. There's a lot of side effects. And we work with a lot of shelter residents to file for reasonable accommodation requests to get ACs because of their health conditions, but a lot of people don't really know that that process is available. And even when we file, it can take weeks and months for people to be accommodated, during which their health is at risk. And we still encounter people who have granted reasonable accommodation requests who are not getting AC. And so we support Intro 1208. We would like to see a requirement that every shelter have AC, but we would also urge that the report include for each agency the number of reasonable accommodation requests filed for AC, the number that are actually fulfilled, and then the time it takes to fulfill those from the time the request is submitted. And then turning to Introduction 791 really quickly, there's only one available supportive housing unit for every 5 people eligible, but it was reported by the city, the publication, back in January that there's over 4,000 vacant supportive housing units. And so, this bill would speak to those vacancies, but some of what we have learned from our programs who help place people in supportive housing is that there can be issues with units that make them not appropriate for people. So some of the units can be shared units, and for people, especially those who may have psychiatric disabilities, that's just not a situation that works for them. Some of them are older and need repairs. Some of the units are funding streams where they take 70% of a person's income rather than your typical 30% towards rent, which actually just doesn't leave people money to live with. So we would really urge that the report go deeper into why these units are vacant, what are the necessary fixes that are needed perhaps to make these units meet the needs of people who are seeking supportive housing, and also understanding more deeply what are the different funding streams for these vacant units, so we can really drill down into why the units are vacant instead of just having a static report that they are vacant. And then the final thing I'll note just about that is that That bill only covers units that are in the CAP system, the Coordinated Assessment and Placement System, and that's not all the supportive housing in the city. The CAPS has about 36,000 units in it, but there's over 40,000 supportive housing units in the city. So if we just make this about what is in CAPS, then it's just not going to capture the full extent of vacancies because not every unit is in CAPS.
I appreciate that, and our team is taking notes.
Yeah.
Thank you.
Thanks.
Good afternoon, Deputy Speaker Ayala, staff, and members of the committee. My name is Jonathan Chung, Director of Public Policy and Advocacy for the National Alliance on Mental Illness of New York City, or NAMI NYC. Thank you for holding today's important hearing. We are grateful to you, Speaker Adams, and the entire City Council for recognizing the growing mental health crisis in New York City and for working in a comprehensive manner to try and address this issue. Even with the work that has been done to date, much more still needs to be done to address the gaping holes in our mental health care system. In addition to the many operational and funding gaps, a major issue plaguing the behavioral health community is a depleted and overworked workforce. We are currently experiencing a shortage of social workers, depriving many New Yorkers of the community-based, culturally competent care that they need. Factors such as low pay, high caseloads, and increasing burnout are significant reasons for these shortages. Another reason, a biased licensing exam. Many New Yorkers have completed their Master of Social Work, yet struggle to pass the third-party written LMSW exam. The Association of Social Work Boards, ASWB, who administers these exams, own data shows that there are glaring racial and age disparities in pass rates for the exam, particularly amongst Black and older test takers when compared to their white and younger counterparts. There are several states in the nation that do not require a licensing exam. One of those states, Illinois, can be a good case study on how removing the licensing exam can positively impact the workforce shortage. In 2021, recognizing the glaring racial and age disparities in the test, the Illinois state legislature passed and the governor signed legislation to abolish the exam. By the end of 2023, the Illinois chapter of the National Association of Social Workers reported that more than 10,000 new social workers entered the workforce during this time. NAMI NYC is a proud member of the Social Workers for Justice Coalition. We join the call in advocating for the passage of the Social Worker Workforce Act in the state legislature, and we join them today and the Councilmember Bottcher in support of passage of Council Resolution 362A. Urging the state legislature to enact this important piece of legislation on the state level to significantly address the workforce shortage crisis we are experiencing. Thank you again to the committee for your consideration of our testimony. We appreciate all your efforts, and we look forward to continuing doing this important work together and being a resource to you all. Thank you.
Good afternoon, Deputy Speaker Ayala and members of the committee. My name is Luisa Lopez, and I'm the Executive Director of the Latino Social Work Coalition Scholarship Fund and co-chair of the Licensing Committee of Social Workers for Justice. I'm here today to urge the Council to pass Resolution 362 in support of the Social Work Workforce Act. New York City is in a mental health crisis, and we see it every day on the train, on the bus, and on our streets. Communities of color, especially, are facing compounded trauma, housing instability, and immigration stress. They deserve a workforce that reflects their realities, speaks their languages, and understands the context of their lives. But right now, the very professionals that we need, multilingual, culturally competent social workers, are being locked out of the field by an outdated and discriminatory licensing exam. Social workers are the backbone of New York's mental health infrastructure. 75% of all mental health services in this city are delivered by social workers, and 80% of our clients are people of color. But our workforce does not reflect our client base, and agencies across the city report critical shortages and have reported critical shortages for a long time, not because of a lack of talent, but because of outdated and discriminatory barriers to entry, like the ASWB exam. Let me be clear, this is not about lowering standards. Every other requirement for licensure would remain in place: graduate education, supervised field work, and coursework. This is about removing one arbitrary, unvalidated exam that has never been proven to measure clinical competence and disproportionately blocks social workers of color from entering the field. The mental health crisis is now, and we cannot keep asking New Yorkers to wait. The workforce shortage is now, and the moment to act is now. By passing Resolution 362, the Council will be taking a powerful stand for equity, mental health access, and a workforce that truly reflects and understands our communities. Thank you for your leadership and for recognizing that mental health care doesn't just require more social workers, it requires the right social workers. Thank you.
Good afternoon, Chair Ayala, the Committee on General Welfare, for the opportunity to testify on behalf of the Social Work Workforce Act. I'm Siobhan Naboa, Associate Executive Director for Older Adult Services at Sunnyside Community Services, a proud social worker and a member of Social Workers for Justice. A little bit about Sunnyside Community Services. We're a community-based not-for-profit, and we believe that every person deserves meaningful support to achieve their aspirations, and we're proud to serve over 16,000 people across Western Queens and beyond. As a lifelong advocate for older adults, I'm deeply concerned about the unacceptable delays in care our older adult clients face due to a shortage of licensed master's level social workers, and this testimony will highlight the urgent need for change. So we know there's a growing number of master's level social workers who are ready, willing, able to serve. You're going to hear from them today, but they're held back by a requirement to take an exam that doesn't reflect their ability to provide high quality, competent care. These are social workers, many of whom are bilingual, culturally competent, reflecting the vulnerable communities that need their services most. We need them, and I can't say that enough. They're essential in meeting the growing mental health needs of older adults, but the odds are stacked against them as they're expected to pass an unbiased and unscientific licensing exam. So at Sunnyside, we provide geriatric mental health under one master's level social worker, one. He provides services to older adults facing isolation, depression, anxiety, and the added challenges of living with chronic illness as older adults continue to live longer. He leads 3 support groups, each one with over 20 older adults participating. And then he does one-on-one counseling sessions. This fiscal year, he's already seen over 220 clients and counting. That's an incredibly overwhelming caseload for one social worker. When he can't, and he has to create a wait list, he refers out to community-based services, where unfortunately for clients, especially Spanish speakers and those for whom English is a second language, they often wait weeks or months for an appointment to seek mental health care. We should all be outraged here. We need more social workers to manage growing caseloads and meet the needs of our aging populations. So Sunnyside is just one agency grappling with this challenge. Multiply the issue by many other community-based nonprofits across New York City and the state, and the siren gets louder and louder. So I'd like to end today, Chair Ayala, on a personal note. In 2020, I lived in Corona, Queens. That's my neighborhood, and we were the hardest hit in the pandemic. My grandfather died after spending 5 weeks in the hospital, and I lived with 4 generations in one roof without the ability to isolate and without the advantage of vaccines. In the aftermath of his death, my grandfather, Tobias Noboa, one of my family members was paralyzed by grief, and I spent months searching for a licensed social worker to provide grief counseling. There simply weren't enough social workers. The doors were closed, there were no wait lists, there was no access to mental health care for my family member. We were ultimately able to find a student psychologist at a school-based mental health clinic, but that experience fell short of the care they needed. As a social worker, I couldn't help my own family member. It felt like a personal failure, but let's be clear, it was a systemic failure that affects far too many in our community. So I would appreciate the endorsement of New York City Council for the Social Work Workforce Act. It would send a clear message that we as a city, we're fully committed to prioritizing mental health and the well-being of all New Yorkers, especially older adults, and that we recognize and elevate the vital role of social workers in this effort. This isn't just policy change, it's a call for justice and equity in mental health care. Thank you.
Thank you so much for sharing that. My condolences. I recognize everything that has been said as, something that we need to work harder to address. I think one of the ways that we've been trying to be helpful is creating, independent of the licensing issue, is also how do we engage Black and and brown folks into the social work field? How do we bring them on board? How do we keep them? How do we retain them in our communities? Because they're coming out of school with debt already, and not being paid adequately, right? So we have been having those conversations for a number of years. It's been a couple of difficult fiscal budget cycles, so we haven't gotten to the point where we have fully funded that initiative, but I look forward to ensuring that it is there so that it offers some financial relief to students that are in that field that would commit to working in communities of color for a number of years. So that way, we don't have the excessive turnover with the limited staff that we already have available. But thank you all so much, and thank you for the work that you do. I know it's important work, and we appreciate it. Thank you. Next panel, Gabriela Amarariz. I'm sorry if I mispronounced it. Jacqueline Mandros, Ellen Mishikinsky, and Maria Lizardo.
Hi all, my name is Ellen Mishinsky. I am a current social work student pursuing my master's at NYU Silver, so thank you to the committee for the opportunity to testify today. So I'm here with Social Workers for Justice, calling on the council to pass Resolution 362A in support of the Social Work Workforce Act, eliminating the entry-level licensure exam for social workers. Now, I'm someone who has always thrived in academic settings. I'm just like a huge nerd, and so next year I'm gonna be able to take that prep course, study, pass that exam. It's not gonna cause me too much stress. But I did still come out here today to talk about the elimination of this exam, because for my colleagues and classmates who are just as, if not more equipped than me to do this job, this test is a barrier to entry for their opportunity to do this critical work. The ASWB licensure exam was designed for people exactly like me, privileged, academically inclined white women. But the field of social work needs to include more than just people like me, people who have the experience and the understanding of the marginalization and the struggles that clients face. This diverse city needs a workforce of diverse social workers to improve our ability to address people's needs. Everyone is talking about how we need to address this mental health crisis, and passing this resolution can bring us one small step closer to that. It opens up the door for professionals who have meaningful experience in the field to fill the vacancies where more social workers are desperately needed. People who are fully qualified, master's level professionals who just couldn't afford the expensive prep material to navigate this exam that doesn't measure competence, but rather wants access to resources and test-taking tips and tricks. The exam requirement for licensure is a discriminatory barrier for individuals, as well as a barrier to this city providing the level of quality services that New Yorkers deserve. So I ask you to pass Councilmember Bottcher's Resolution 362A, support the Social Work Workforce Act, to empower the incredible social workers on the front lines of this mental health crisis. Thank you.
Thank you.
Good afternoon, and thank you, Deputy Speaker Ayala, for having us today. I am Maria Lizardo, and I'm the Executive Director of NIMIC, a settlement house serving 14,000 community members in Upper Manhattan and the Bronx. I am a proud social worker, a graduate of Hunter College School of Social Work, where I majored in community organizing. I'm here today as a member of Social Workers for Justice. Thank you for the opportunity to testify at today's hearing. I am testifying in support of Resolution 362A, which is in support of the Social Work Workforce Act. This legislation would eliminate the entry-level ASWB licensing exam as a condition for licensure because of its long-standing and extreme racial bias and pass rates, and it lacks the evidence that it scientifically measures the competence of social workers. 49% of Black social workers and 62% of Latino social workers who graduate pass the exam, in comparison to 88% of white social workers who pass the exam. This exam excludes the very social workers we need, most of them practicing, and those who reflect the populations we serve in high-need communities in both public and nonprofit agencies. When I graduated in 1997, a long time ago, I had no intention of taking the exam. After spending 2.5 years in school, completing 2 semesters of an internship, and having worked in the field, I was not going to let the exam be the only measure of my social work skills. Although years later, I was able to obtain my license when the licensing regulations changed and I was grandfathered in, I still firmly believe that the foundation of my skill sets are based on the academics, good supervision, and experience in the field. A biased test cannot and should not determine people's employability and skill sets necessary in the field. New York State would not be the first state to eliminate the social work licensing exam. When Illinois passed similar legislation in 2022, they welcomed 10,000 new social workers in 2 years. Rhode Island doubled their workforce. We're likely to see an increase of 20,000 social workers when the exam is eliminated, and they will deliver the essential mental health services that New York City and New York State needs. To summarize, I submit this testimony in support of the resolution submitted by Councilmember Bottcher and the Social Work Workforce Act as sponsored by Senator Brooke and Assemblymember Jessica Gonzalez Rojas. Thank you for your time.
Hello, good afternoon. My name is Gabriela Morales, and I'm a graduate student at Columbia University. I work at a psychiatry office where I have been employed for the past 8 years. I'm also here today as a member of the Social Workers for Justice. Thank you for giving me the opportunity to testify at today's workforce hearing. I'm testifying today in support of the Resolution 362A, which supports the Social Work Workforce Act. This legislation would eliminate the ASWP licensing exam, citing its documented racial bias in pass rates and lack of scientific validity in measuring social workers' competence. I'm fluent in 3 languages, and my goal is to broaden my skills to help non-English speakers that are treated unfairly every day. During my first year of graduate school, I completed 600 hours of clinical work under supervision, where I provided therapy for non-English speakers to support their mental health and help them navigate crisis. The burden of passing this standardized exam next year is affecting my well-being, as English is my 3rd language. Many people are choosing not to pursue master's degree in social work due to the disproportionately low passing rates for non-native speakers. Rhode Island, as my colleague said, doubled their workforce. We are likely to see an increase of 20,000 social workers when the exam is eliminated. They will deliver the essential mental health services that New York City and New York State needs. To summarize, I submit this testimony in support of the resolution submitted by Councilmember Bottcher and Social Work Workforce Act as sponsored by Senator Brooke and Assemblymember Jessica Gonzalez Rojas. Thank you so much for your time.
Good afternoon. I'm Jacqueline Mondros, and I've been a social worker for 52 years. Former Dean at Hunter and Dean and Professor Emeritus at Stony Brook University, I have literally worked with thousands of social workers. Thank you, Deputy Leader, for the opportunity to testify today on behalf of Resolution 362, which supports the Social Work Workforce Act. We are 7 days away from the mayoral primary. Every candidate has proposed an expansion of mental health services, and indeed the City Council has also supported the expansion of such services. And for good reason. We are in all of the services that you mentioned today: domestic violence, schools, homeless services, healthcare, justice and courts, Rikers Island, wherever you can think of, we're there. And as you yourself said, a good social worker is worth her weight in gold. She sees things no one else sees. She says things that no other person will say. And she cuts through the red tape that gets people the services they need. 75% of all services are delivered by social workers, and we don't have enough of them, and the ones we do have do not adequately represent the communities we serve. The obvious and indefensible obstacle to growing our workforce is the entry-level ASWB exam. It has a long-standing and national track record of extreme racial bias, and it doesn't follow any of the standards for psychological and educational testing, which would ensure its validity, reliability, and norming to different groups. We have been asking ASWB since 2014 to fix this exam, and the disparities have only worsened. And yet the outcomes have such serious consequences. More than half of Black graduates and more than a third of Latino graduates fail the exam, and that prohibits them from working as social workers. Others today will testify on the disastrous impact of that. We applaud all of our public officials for proposing more funding for mental health services. It is urgently needed and important, but it won't make a bit of difference if there is no one to fill those jobs. If we pass the Social Work Workforce Act, we will put thousands of new and culturally diverse social workers to work in our communities. If we delay, we won't. It's really as simple as that. We urge you to support Resolution 362 and to urge our state legislature to pass the Social Work Workforce Act. Thank you for hearing our testimony.
Thank you. So nice to see you.
Good to see you.
Thank you. Thank you, guys. We're going to call our next panel. Stella Doritz, Maria Miranda, Grace Downs, Yusuan, and Tara Escudero Alamed. You may begin.
Oh.
It'll, you know when the red light is on. Yeah.
My name is Tara Escudero Alameda. Thank you, Chair, for taking this opportunity to listen to my story. I was impacted. I was terminated due to the licensing exam. I became a school social worker for the New York City Department of Education, working with students with disabilities since 2014. In 2021, I was terminated. Prior to, the testing sites opened up because during the pandemic they were locked, closed down. I had to fly to Georgia just to sit for a seat. None of the neighboring states or New York had any seats available. I do suffer from testing anxiety, so I get extra test time. It impacted my life because I took a huge pay cut. My family, my quality of living, making me feel like a failure. I've taken it 11 times and saw on the screen failed and missed it by a few points. And I always thought there was something wrong with me. I was doing like therapy, all these different things. To come to find out, they released the data that there's nothing wrong with me and there's everything wrong with this exam. I still work for the schools. I had to take a demotion position. And I have licensed social workers coming to me for support and guidance. And I'm not gonna stop supporting my community because at the end of the day, they still need me, but it has impacted me so much. And all I crave for is my job back to be in my rightful seat, because a lot of people that are passing, they don't know anything. So we need to be able to push this bill so we can work with our communities. Thank you.
Good afternoon. Thank you, Deputy Speaker Ayala, for the opportunity to testify today. My name is Maria Miranda. I'm a member of Social Workers for Justice, and I'm a Bronx-based social worker providing in-home support and services to homebound older adults and their family caregivers, a majority of whom are people of color. I work at Presbyterian Senior Services, an agency that contracts with New York City Department of Aging to provide case management services to these Bronx older adults and their families. I'm testifying today in support of Resolution 362-A, which supports the Social Work Workforce Act. I'm in support of this act because the ASWB exam does not and cannot measure the true essence of our profession, which is the bond we develop with our clients. These bonds are formed through trust, rapport, and collaboration, and are especially strong when social workers and clients share the same language, culture, and lived experience. In the 3 years that I've been a social worker, I've been able to facilitate the greatest change within my clients by using my lived experience as a caregiver to my late grandparents. The only thing that the ASWB exam measures is one's aptitude for test taking. This was said to me directly during one of my test prep sessions. I was told to ignore my field work in favor of recalling a list of strategies for different questions, and to even imagine the clients as people who live in Middle America. Now, if that doesn't indicate bias for a certain group, then I don't know what does, and it's certainly not reflective of the Bronx. It needs to be understood that clients throughout New York City are not Middle America, and the scenarios we encounter are not AI generated. Clients like mine in the Bronx look for authenticity that can only be learned by listening and understanding their stories, by meeting them where they are, and by social workers who respect and understand them. And on a personal note, I am deeply concerned for the 1.3 million caregivers in New York City who are in a very serious mental health crisis. They are having to balance caring for their family members, caring for themselves, and having to face a system that continuously ignores their basic needs. They need our help, and they need social workers who understand them. I end this by encouraging the City Council to support this resolution submitted by Councilmember Bottcher and the Social Work Workforce Act as sponsored by Senator Broke and Assemblymember Gonzalez Rojas. Thank you for your time.
Good afternoon, and thank you, Chair, for your time. My name is Dr. Grace Downs-Lagori. I hold a doctorate in social welfare, and I'm a clinical social worker. I'm here today in support of Resolution 362A, calling on the New York State Legislature to pass the Social Work Workforce Act and eliminate the ASWB test requirement for licensed master social workers, an obvious obstacle in expanding the social work workforce to New York City, especially for immigrant communities. I currently work as an oncology social worker in Queens, the most diverse county in the United States, and I have spent the last 10 years of my career working in medical settings, primarily with immigrant individuals and their families facing life-altering illnesses and disabilities. It can be next to impossible to find adequate supports and mental health services to meet the needs of my clients, most of whom require culturally informed and adapted mental health services in their native languages. Immigrants face disproportionate disparities in cancer care, including financial stress, and many struggle in adjusting and coping with their cancer diagnoses. And in many ways, it impacts their lives, hopes, and aspirations. Many are unable to access needed mental health services due to the shortage of diverse bilingual social workers in our city. Most recently, I have worked with clients who are Bengali-speaking, Urdu-speaking, Spanish-speaking, Chinese-speaking, who are in need of support after receiving advanced cancer diagnoses and are having difficulty coping, not sleeping, ruminating thoughts and worries, but we cannot find services, and many of them, when I do find services, many of them have to wait on wait lists for months to speak to the one Bengali mental health provider in the area. We need more social workers, and particularly diverse social workers, to meet the needs of their clients. I urge you to pass Resolution 362A supporting the Social Work Workforce Act. Thank you.
Sorry.
Thank you. Good afternoon. My name is Shelley Horowitz, and I thank you for the opportunity to testify in support of the Social Worker Workforce Act. I'm an assistant dean at the Stony Brook School of Social Welfare's Manhattan site, which is located across from Bryant Park. I've been a social worker for over 40 years. In my capacity at the school, I teach, hire adjuncts, advise students one-on-one, develop continuing education programs for New York City social workers from DSS, HRA, DHS, and among my other responsibilities, they oversee our licensing preparation courses. My amazing and dedicated students reflect the demographic of New York City and are primarily students of color. Many of my colleagues have spoken about the exam's bias and provided a number of statistics. I would like to speak from my perspective as a social work educator and share two stories reflecting the negative impacts of the exam and how it stands in the way of qualified social workers. The first is how one of my students working in child welfare lost her job after failing the exam. A condition of her employment was to pass the exam within a year of hire. Everyone lost. This highly committed social worker on the front lines, as well as her clients. She felt humiliated, depressed, and desperate. Who does this help? One of my adjuncts, let's call her Carolina, had years of direct practice experience with DV and justice-impacted patients. She failed the exam 5 times, but eventually passed it after investing thousands of dollars in licensing preparation courses and on the ASWB exam. Carolina is a single parent of 3 children. She's also responsible for her father, who has Alzheimer's disease. She pays for his care out of her pocket. To support her family, she works 2 full-time social work jobs. She did not need the additional expenses associated with the ASWB exam. It should not be this hard for social workers who are committed to making the world a better place to become licensed and to find employment. The exam is a major roadblock. It acts as a barrier, and it's a revenue source benefiting only ASWB and harming New Yorkers who desperately need social workers. Thank you for your time and support.
Thank you. We have quite a number of people still, so we're not trying to move it along, sorry. Shai Yang, Allison Jordan, I think. Kiva Fakir, and Allison Rosenthal.
That's fine, I can do it. No, it's fine, that's for you. Yeah, we should let them go first. Yeah. You should go first. Oh. No. Let's let them go first, yeah.
Okay, you can begin. No, is the red light on?
No, there we go. All right, well, thank you to the General Welfare Committee, Chair Diana Ayala, for holding today's hearing and the opportunity to submit testimony. My name is Allison Rosenthal. I'm the Chief Program Officer and Registered Dietitian at the Westside Campaign Against Hunger. We're an anti-hunger organization that for 46 years has been focused on providing access to healthy, fresh produce and direct benefits enrollment to New Yorkers in need. Last year alone, WISCA provided over 5 million pounds of food to 110,000 New York City customers, which included the distribution of over 3 million pounds of fresh produce. The Westside Campaign Against Hunger's mission is to make sure all New Yorkers have access with dignity to a choice of healthy food and supportive services. Right now, we are experiencing a hunger crisis. Even prior to this new federal administration taking office, 1 in 8 New Yorkers were experiencing food insecurity, and that was up from 1 in 10 the year prior. The number of people seeking food from our organization is at an all-time high, and we need the city's help. Today, I was joined by dozens of emergency feeding organizations on the steps of City Hall, urging you all and the mayor to increase the Community Food Connection Program, CFC, the funding from $57 million to $100 million. Collectively, the emergency food programs in New York City serve over 3 million hungry New Yorkers annually. they rely on us to help feed their families. The current proposed budget of $57 million is simply not enough to meet the growing demand for food. SNAP cuts are looming, federal budgets have been cut, grocery prices are continuing to rise, and we need for our city to step up. The CFC program budget needs to be significantly increased to $100 million, and that money needs to be baselined in the budget. We urge you to do the right thing and to increase CFC to $100 million. We appreciate your leadership and we're grateful for your support. Thanks.
I poured some for you. Oh, thank you. Hi, I do apologize. This is my first time ever being to one of these council meetings, and this is a bit after I've been in an accident and I've been abused for a bit. So I do apologize if I'm not up to par on every aspect of where I can fully see an envisionment for where I see not just legislation, but also the people being able to reap the most of what we have come to fruition in our society today. But in part with what it is you guys are testifying to in terms of social work, I don't want anybody to think I'm in opposition to the growth and expansion of healthcare services or like the general welfare, if you will, for community standards. It's one of the greatest things that we could ever ask for. One of my key things with that is just if we can streamline a concise and stable ecosystem in where it doesn't necessarily cross over into violating the natural rights that we have established with time and with how far we've come from a lot of the things that we've experienced historically in history, but also being able to not necessarily grow a dependence on these resources, in the sense that not that we're not saying to establish and maintain a fund pool for those services, but being able to expand from where we are socially to a more independent individual like nature with time. Separate from that, what it is that I was here to be able to speak to, in addition to necessarily just saying, like, for example, I'm a bit underweight. I was wrongfully incarcerated going to school out of state for a bit, and I told everybody the case was going to get disposed. It did. But I have experienced residual effects. I've lost my job. I get paid less. And not to say that that's necessarily what I'm, like, complaining about. But those are just some of the things that have been affected. You guys had legislation come into effect about in 2020. I tried to file an injunction, but with my disability, getting both my hands crushed in the door at the shelter and losing my apartment, it's been a bit hard to stay on track with getting work done. I also was recently hit by a car again after I was as an adolescent, close to almost a year ago from today. All I'm saying is I was hospitalized. I do apologize to go over just a little bit. I have a disability, just give me 2 more seconds. I was hospitalized several times. I started experiencing lockjaw. I start foaming at the mouth from the oversecretion of mucus in my brain as a result of my brain injury from a child. But the side effects of the heavy medication, these hospitals aren't honoring when you're saying objection over medication. You're not seeing the judge before they're medicating you. And on top of that, the social worker team is not being as, I get it, they're only there Monday to Friday from a certain time to a certain time, but they're not being as diligent as they can be in advocacy. I have a traumatic brain injury. I've had over 5 concussions. I've been banned from being able to play collegiate sports for the rest of my life. Even if I went and got my master's, I can't do it. Like, I said, can I take some time off? They said no. So I've tried to work very hard in being able to to maintain and reestablish my medical regimen and being able to be an independent version of myself and completing those daily activities of living. But like, for example, one thing that I've asked for is, hey, is there a way that I was attacked in handcuffs at the HRA office. The government system doesn't want to allow me to get a phone. They keep cutting it off. Every 5 seconds, they send me a phone, and like, I'll use the phone, make one phone call, the phone cuts off. I can't do the interview for my HRA. They rejected my application. They told me I need to wait for a court date from the OCDA office. It's taking like forever. I've been asking since January. I'm having difficulties. At one point, I was having difficulties being able to find nutritional
wrap up because we have a few people
resources. What I'm saying is, with time, there's a lot of distress out there, right? There's the honking, there's the there's the parking in the crosswalk. There's the people that they stop their cars in the crosswalk and then pretend like they were doing you a service by telling you. There's the people sitting on the train that's pointing their cameras at everybody. There's the other people who are sitting there like being unaware and mindful of others in their daily activities of living. And all I'm saying is, as an individual with a disability, I asked social services to be able to get nutritional resources on my way out the hospital. They refused to even let me get dressed inside the hospital. They refused to get me any insures or nutrients or any of that stuff, despite what my circumstances was. What I'm asking for is for a proposal for budget funding to be able to establish an OTC fund card, a manager credit booster OTC fund card. So if you partner with the bank, you can establish an account plus, right? These businesses should be able to streamline their finances through a government account that would allow us to establish OTC funds that would allow individuals like myself to be able to have resources. What I'm saying is, if we can provide funding for social services, what I'm saying is those services should be available.
I'm sorry, honey. We can talk after, okay? Give me a second.
Oh, there we go. Hello, good afternoon. My name is Allison O'Connor Jordan. I'm here to share my reasons for supporting Resolution 362 and the Social Work Workforce Act. I also shared with you my CV so that if you have other questions about things that have been testified about today, like we thought JIGIS was the solution and apparently it's not, too bad. I'm here to answer questions as you need. I am a licensed social worker. I began my career as a program director in New York City's largest senior center, and I graduated from CUNY's Hunter College School of Social Work. I retired from New York City government after 39 years in February of 2020. I worked at HRA and the Health Department. I now support implementation of proven models and volunteer with national organizations to advocate for policies that support continuity of care and services after incarceration. Throughout my career, I encouraged many to enter the field of social work and mentored dozens of primarily Black and brown social work students and early career professionals over 30 years, I think, signing off on thousands of completed internship hours. I did this knowing that one day I would need to have the talk and advise my mentees that in order to pass the LMSW exam, you need to think like someone who looks like me, an older white woman, not me, but afraid of Black and brown men, and take the exam through that lens. Those who find a way to pass, often after many tries, arguments with their conscience, must ignore best practices and social work values. They take expensive prep courses they can't afford and carry extreme financial burdens. As you've heard earlier, white women like me pass the exam. People of color do not. We know the exam is unnecessary and indeed detrimental to the profession. Initially, it was waived for those of us with experience and supervisors' attestations. Today, the exam is a disservice, creating barriers to accessing social work services for those with the greatest need, and it really needs to be eliminated, so we applaud your efforts. People incarcerated are overwhelmingly Black and brown. Those from the poorest areas are Black and brown. Social workers with lived experience, reflective of the people in need of social workers most, matters. It matters to the profession. It matters to us all. I want to thank you for your time and submit this testimony in support of the resolution submitted by Councilmember Bottcher and the Social Work Workforce Act, as sponsored by Senator Broke and Assemblymember Jessica Gonzalez Rojas. And I thank you very much for having this hearing and for welcoming us today.
Thank you.
Hi, thank you so much for having us here. My name is Sai. I'm a social worker fighting for justice. I would like to thank you all again for just having us here and holding this hearing for it's critical for social workers. I am Hmong, it's spelled H-M-O-N-G. It's an indigenous ethnic group from Southeast Asia who helped the United States fight in the war, and that's why we're here. I'm a refugee family. My mom and dad are refugees, and 9 siblings. I've dedicated my life as a social worker to as well serving the communities here in New York City. And I'm coming here to just to serve and give back and talk about our experiences with the exam. Now as a social worker, I've been here for 10 years. I worked in family court, foster care, ACT team, mobile crisis is what I'm doing right now in Brooklyn. And I see it every day in Brooklyn, how intense the mental health crisis is. And we need more social workers. We need more diverse social workers. We need more, due to the broken system, it's affecting us. I am overwhelmed. I've never been at a place to saying that we are fully staffed. Almost always someone's leaving, almost always someone's picking up for someone else. So as you can imagine, that trickles down to our clients. We have recent graduates. We have social workers such as Tara who spoke, who cannot pass their exam. They are here, you know. And how do I know? Because I failed myself in 2012. So it took me 7 years to have the courage to do it again. And I only did it because I had to. It's horrifying and devastating. And we want to not have the future generations go through that as well. Sorry. Passing the exam allowed me to serve my community more. And I want to give other social workers the opportunity. This exam is restrictive. So thank you for your support. I come with you all with passion, dedication, and personal obligation for the next generation, and let's make it a reality.
Thank you, and thank you all for coming to testify. We have quite a few people online waiting to testify as well, so I'm trying to move it along, but thank you all for coming. Christopher Leon Johnston, come on up.
Yeah, hello. My name is Christopher Leon Johnson, and I'm supporting Eric Bottcher's resolution for the Social Worker Workforce Act. We need more social workers in the city of New York. At the same time, I'm calling the city council to defund all cure violence nonprofits, because I see that these nonprofits are taking all that money and they're not doing the right thing with the money. They're saying that they're going to take that money and hire social workers and hire these type of people that they should be hiring, but they're not doing it. And that money should be defunded out of these budgets, out of the next mayoral budget and the executive budget to the city council, and give it to these social work organizations. We need these workforces. I like social workers. They do a lot of great work for the city. They help me out when I need their help, so I don't have an issue with that. But one thing I want to make clear is that when it comes to the SNAP fraud stuff, why did the city cut that off with SNAP fraud? I mean, I know there's somebody that I know that had SNAP, and they took her money away, and they couldn't reimburse her the money because they went to the store and bought out the SNAP, and they swiped it one time, and some shady store person took the pin, and then the next 2 days it was gone. I know before, under the mayor and the governor, when you had SNAP, when you lost your SNAP through fraud, you can get that reimbursed. I don't know why that they decided to cut this off. I think it was a bad mistake by the mayor administration to do that to everybody. I mean, there's still SNAP fraud going on in the city. So I'm calling the city council to find a way to put that program back into to where it is, because a lot of people will need that. I understand that you can't go back and do prorated, but if you do it now or later on down the run, it will help people out going forward, because I know there's a lot of people in the city that go through SNAP fraud, and it was wrong how they was treated with that. So I say I'm calling the city council to stand behind that. So back going to the social workers thing, like I said, I hope you pass that bill with Eric Botcher, that resolution for the Social Workers Workforce Act, and it should go through. And like I said, the SNAP fraud stuff like that, they need their money back. They all need their money back. It was wrong how they was treated, and hope the city council does the right thing and help push all these bills to go through. So we need more social workers, and like I said, that was wrong how people get treated with SNAP fraud and how they're not getting paid back. So yeah, so hope these bills go through, and thank you so much. Enjoy your day. Thank you.
Thank you, Christopher.
Thank you.
Thank you. We'll be moving on to our online panel. And we will begin with Shakira Kennedy.
Again?
Shakira?
Hi. Okay, I was just unmuted. Thank you.
Thank you.
Hopefully you could hear me and also see me. Good afternoon, Chair Member Ayala and the members of the Committee on General Welfare. My name is Dr. Shakira Kennedy, and I'm a licensed social worker and the Executive Director for the National Association for Social Workers in New York, representing over 9,000 social workers across the state. Today, I offer testimony on behalf of our membership and the NASW Board of Directors and NASW's partnership with Social Workers for Justice in strong support of Resolution 362A, the Social Work Workforce Act. We support this resolution because we have heard, and many of us have lived, the stories of those demoralized and discouraged by the Association of Social Work Boards, ASWB licensure exam. Whether they ultimately passed or failed, the experience is too often marked by anxiety, fear, and financial burden. Many test takers report doing everything right, enrolling in prep courses, studying extensively, and taking the exam early, only to fall short of passing by a few points. One test taker described the exam as bogus, expressing disbelief at failing multiple times despite rigorous preparation, and afterwards calling it a profit-making machine. Another said, I failed my exam for the third time. I feel stupid and hopeless. It's like ASWB doesn't want you to pass. These sentiments are not isolated. They are far too common. The cost of taking the exam can exceed $800 when factoring the multiple attempts, study materials, and test prep services, an expense that affects social workers who are not paid adequately throughout New York and disproportionately candidates of color. I know this because I myself have lived it. After graduating from my MSW program, I took the ASWB exam and failed by 1 point. I was devastated. Years later, I tried again, this time failing by 2 points. The feelings of inadequacy, frustration, and professional stagnation were overwhelming. It wasn't until after I completed my doctorate and was teaching full-time at a graduate school of social work in New York City that I felt more confident to try once again. What changed? I didn't study the content. I studied the test. I had to unlearn what I knew about social work and learn how to take a standardized
Your
test.
time has expired. Thank you.
You can also submit your testimony, your written testimony, to the council for review. Next person is Jocelyn Narciso.
You may begin.
Jocelyn?
Sorry, I wasn't able to unmute on my end. Hi, thank you so much for letting me speak. My name is Jocelyn Narciso Molina. I am a proud daughter of Mexican immigrants, a recent MSW graduate, and an advocate for social workers for justice. And I'm here in full support of the Social Work Workforce Act and the removal of the LMSW exam as a requirement for licensure in the state of New York. New York State is facing a growing crisis in equitable access to culturally competent mental health service and social services. Immigrant communities, including the backstretch workforce at Belmont Racetrack in Elmont, where I was raised, are among the most underserved. This labor force, primarily composed of Latino immigrant workers, many of whom are legal permanent residents or on a pathway to citizenship, operate in an isolated, high-stress environment with limited access to care. Language barriers, stigma, and the lack of culturally responsive providers make these challenges worse. The current licensure process, particularly the LMSW exam, adds another barrier, not just for aspiring social workers, but for the communities who depend on us. The test does not assess compassion, lived experience, or community trust. It reflects privilege, rewarding those with access to test preps, time off, and fluent academic English. It weeds out brilliant bilingual community-embedded professionals who have already proven their readiness in real-world settings. According to the ASWB, pass rates for Black, Latino, and multilingual test takers are significantly lower than those of their white test taker counterparts. This isn't about merit, it's about systematic exclusion. And the cost of the exclusion is real. Communities like mine go without care, and dedicated social workers are kept in limbo or pushed out altogether. The Social Work Workforce Act provides a path forward. By removing the LMSW exam, it opens the profession to a broader, more diverse group of candidates, many of whom are already serving on the front lines. It creates a licensing structure that reflects what the work already requires: trust, cultural competency, language access, and sustained supervision, not standardized answers. So I please ask you to support the Social Work Workforce Act. Thank you so much.
Thank you. Our next panelist is Nancy Gallina.
You may begin.
Thank you. My name is Dr. Nancy Gallina, and I'm appearing before you today as the Dean of the Touro University Graduate School of Social Work here in Manhattan. Touro has been involved in the issue of licensure pass rates for several years. We have met with all the state and national social work organizations working on this issue, and I'm a member of the National Task Force of Deans working to eliminate this exam. We have been actively involved because our student demographic consists of returning adult learners, students for whom English is not their first language, and students of color. The very demographic that is failing their entry-level social work exam as identified by ASWB's own data in 2022. As a result, the pass rates for our graduates as first-time test takers is in the 50th percentile. This pass rate has implications for Touro as an institution, as that the New York State Education Department arbitrarily withholds approval of programs or places stipulations on programs that are tied to this specific pass rate. Currently, NYSED has a cap on our enrollment, which is preventing Touro from educating those who would choose to go into the field of social work at a time when social workers are so desperately needed. Touro's mission and the mission of Social Work School is to create opportunities for education when there has not been opportunity before. We have been the recipient of federal funding for disadvantaged students for the last 8 years. This grant allows us to subsidize up to 90% of tuition for students who are eligible by virtue of economic, environmental, or educational disadvantage. Touro has the lowest private institution tuition rate and a schedule that attracts many adult learners. Since ASWB released their data and because of the extreme disparities, 7 states and the District of Columbia have eliminated the exam, joining 10 states that never had an entry-level exam and 8 others that are pursuing legislation similar to ours. Each accredited social work school must prove students reach competency in 10 areas. This in and of itself is sufficient for licensure at this entry level. This biased and unscientific exam is dashing the dreams of aspiring social workers and a significant obstacle to providing mental health in underserved communities. At a time when New York so desperately needs more trained and committed social workers to work with some of the neediest citizens of our city and environments, we should be creating opportunities and pathways, not barriers. We support Resolution 362A, supporting the passage of the Social Work Workforce Act. Thank you.
Thank you. Our next panelist is Alexei Dmitriev.
You may begin. You may begin.
Yeah, but it's not all of this.
Alexei?
I do it over there. Yeah, over here. I do it over there.
Alexei?
You may begin.
Hello? Okay, Matthew DiCarlo?
You may begin.
Sorry, I was just able to unmute myself. Thank you very much to the Committee on General Welfare. I am here to argue in support of the Social Work Workforce Act. I was asked to be here by Social Workers for Justice based on my series of peer-reviewed journal articles on the psychometric invalidity of ASWB exams. In short, they are not legally defensible and should be abolished. On March 31st, ASWB changed the rules of their exams with negative 15 days of notice. For a long time, their rules were, quote, you'd be given the entire exam time at the beginning of the test. No individually timed sections, manage your time accordingly. The new surprise rule set that was added to the exam guidebook on April 14th is that the exam is divided into two 85-question sections, each of which is a 2-hour time limit. You will not be able to return to the first section. They did not provide advance notice to boards or any equilibration studies of those two versions. They did not even provide notice to test takers until they were literally leaving the test center, or without doing so at all. They haven't responded to the Missouri board's queries about the pass rates during this time, and they still sell practice exams under the old rules. It's really wild. They recklessly change exam structure without the required psychometric tests. So for example, in 2017 to 2018, the pass rate went down from 80% to 70%. Only minoritized test takers remained below average. Per the ASWB, the decline was caused by the 2018 exam blueprint, which changed the versions of the test. We're about to do that again in 2026, but there's no plans to equilibrate the 2018 and 2026 exam blueprints. Similarly, they're going to make significant structural changes to the content areas, down from 4 to 3, no confirmatory factor analysis. They went down from ABCD to ABC answer options. Questions are now 8% easier to guess, 25% faster to read. We have no idea what the impact of these things are going to be because they don't do the required psychometric studies. I offered to do some of them alongside 2 esteemed social work psychometricians for $0 in an open source software package. We were rejected. Instead, they funded a study that found that their 2022 survey results that found descriptive results that sort of motivated this entire session were actually understating it. And the odds of clinical exam failure are 2 to 6.5 times more likely for Asian, Latina, and Black test takers. Despite being a nonprofit, ASWB and its IRS Form 990s revealed an average 17% profit margin, ballooning from under $10 million to over $40 million in net assets. But as New York City knows from the billion-dollar Giulino decision, it's not the test developer that actually faces the music, it's the government organizations and employers that are financially reliable for invalid exams. New York State should follow in the footsteps of Washington, D.C., which removed the exam requirement 2 weeks ago. They joined the 13 other states that license master's level social workers without an examination. Then New York State should form a multi-stakeholder work group of legislators, advocates, and regulators, as Maryland and other states have done, to recommend workforce-wide changes on exams, supervision, and licensure.
Your time's expired. Thank you.
Thank you. Our next panelist is Victoria Rizzo.
You may begin.
Good afternoon. My name is Dr. Victoria Rizzo. I'm a member of several national organizations that support the Social Work Workforce Act. The National Association of Social Workers. I am the past president of the New York State Chapter Board of Directors, the Council on Social Work Education, and the National Association of Deans and Directors of Schools of Social Work. I am a social worker with 35 years of experience as a licensed clinical social worker, an educator, a researcher, and an administrator in higher education. I am here testifying today as a member of Social Workers for Justice. I thank you for the opportunity to testify at this workforce hearing. I am passionately in support of Resolution 362-A, which supports the Social Work Workforce Act. This legislation would eliminate the entry-level ASWB licensing examination as a condition for licensure in New York State. Under my leadership as president, the National Association of Deans and Directors in 2014 conducted the first study in the nation to examine the ASWB examination for racial bias and pass rates based on the experiences of deans and directors and the pass rates they were seeing in their schools in New York State. In 2016, the results of this study suggested the examination was racially biased. We met with ASWB to share our results and to suggest a national study of the examination in collaboration with schools and programs of social work. They refused to collaborate with us and refused to share data with us. The study they released in 2022 revealed that first-time pass rates for Black and Latino test takers were much lower than first-time pass rates than their white counterparts. The New York Deans and the National Association of Deans response was to create their own national task force on licensure, which I am also a member of. New York State is in a severe mental health crisis. New York City and New York State desperately need a diverse pool of social workers who can work with populations that need them the most: communities of color, older adults, children in schools, child welfare, and homeless, to name a few. As an educator, I have witnessed firsthand the anxiety and fear newly graduated MSWs, especially students of color and first-generation students, experience prior to the exam. Many do not pass the first time. Some of my most talented interns and students did not pass the exam the first time, despite their competence. Earning an MSW degree from an accredited school of social work provides them with entry-level competence for licensure. The licensing exam demonstrates no evidence that measures competence. The exam is a discriminatory, systematic barrier to increasing the New York social work workforce in a critical time. I submit this testimony in support of the resolution submitted by Councilmember Bottcher and the Social Work Workforce Act sponsored by Senator Brock and Assemblymember Jessica Gonzalez Rojas. Thank you.
Thank you. Our next panelist is Luis Peña Chalas.
You may begin.
Hi, good afternoon, everyone. And thank you for everyone's time. I'm here because I'm trying to testify against behalf of myself. I'm concerned about HRA's timeline, communication, and the violations of fair hearing court orders. On January 2nd, I applied for a one-shot deal for my rent arrears. Around February 14th, when I had a housing court, I was told that my application was approved, and I went to the HRA housing court office in the Bronx and was given an approved application and handed it to the judge to postpone the eviction until HRA makes the payment. Now, it was not until 2 weeks later that I was trying to contact HRA to try to find out why the payments were not sent over to the landlord, because the landlord had been trying to ask me, where is the payment? And they had told me that they went in the notes and they said that I was not eligible due to my immigration status or my DACA had been expired. So around March 12th, I requested a fair hearing. And on March 25th, the judge had ordered HRA to make the payment. And I'm not sure why 4 months later, almost, I'm still waiting for HRA to be in compliance with the fair hearing decision. And I have court on July 1st, and I have legal aid now involved with this. I also reached out to some of my council members to try to get assistance, but it shouldn't have to be waiting for so long to try to get assistance on behalf of myself because HRA is not in compliance with a court order. It doesn't make any sense. So despite me meeting all the other requirements and income eligibility, I'm still being denied assistance for my rent arrears when I don't understand why they gave me an acceptance notice, then said that Orion had said that I was not eligible due to my immigration status. And I think that people that have expired DACA need to be included in the Orion eligibility standard, because it's not fair that we've been here for so long in this country and we're not treated the same way as everybody else who was born here just because we were brought here through no fault of our own. I think that is totally unjust. And I think that HRA needs to fix their timeline and the communication is not on point, because no one ever communicated to me that I was actually denied after being approved. So the fair hearing judge ordered them to make the payment, and it's almost 3 or 4 months later, and I'm still waiting on HRA to be in compliance. And HRA blatantly said that they're not going to follow the judge's order, that my eligibility doesn't meet the required standard. I just don't understand how that's possible. So I'm just, thank you for your time, and I appreciate it, but I'm just here to voice my concern about the fact that it just doesn't make any sense why HRA is not being in compliance with a court order from a fair hearing judge, and that I have to be going through so much to try to get HRA to be in compliance. Thank you.
Thank you. Our next panelist is Pamela Clipper.
You may begin.
Good afternoon. My name is Pamela Clipper, and I am a member of Social Workers for Justice. Thank you for the opportunity to testify at today's workforce hearing. I'm testifying today in support of Resolution 362A, which is in support of the Social Workforce Act. I'm going to just give you my story, my anecdote. I graduated social work degree in 2016.